And in
Why
this,
are before this court? Why are before this court?
Yes, but how this court can
Lordship,
Is we are not in a position to, we are not the court to identification regarding the identification.
No,
If
Lordship,
you have any
because
doubts, you can make a petition before the land.
case was Lordship, case was filed, Lordship, before the trial court, Lordship, because the accused person is not this person, but
Whatever you
when
make
the
a application before the land
Yeah.
trial court below only, not before this court.
no, Lordship, police is searching me, but no notice, nothing was served.
No, we cannot hold
Maybe
that you are the person or not, you are the not the person.
Then, Lordship,
Yes, regarding identification, we are not in a position to make any clearance in that. What kind of order?
this matter maybe, Lordship, I will appear at the time, Lordship. Let that matter reach, Lordship.
Let me see.
Lordship.
May I please, Your Lordship?
Yeah, you just wait. We are seeing. An order was passed on 21/11.
Yes, Lordship, already.
I don't know why. How now what to do? By what this court will do now? If you're not the person, then why you are praying for anticipatory bail?
Lordship, police searching me because Lordship, can
Now,
you
what
pick up
about the trial court? What the trial court did?
trial court already, Lordship, case that accused, Lordship, already proclaim offender, declare proclaim offender,
Very
Lordship.
nice then.
Lordship, that kindly may come to the page number 17, Lordship.
No,
Okay.
whatever. What the proclaim offender? If he is a proclaim offender,
Lordship, I am not that person, Lordship. But police is harassing me, police is searching me,
that's what I'm
Lordship.
saying. You make the clarification before the learned trial court bullion. That is the court. He can, the court can record even the statement of the eye also. If you're not the person, if you're not the person, that definitely you should not be. Searched
Lordship,
by the
may protect me, Lordship. I will appear, Lordship.
Okay, report
Lordship, for the timing, Lordship, kindly may come to the page number 17.
Received. Issue reminded. List accordingly on 10th of March 2026. Interim be continued till next. Okay. Okay.
Right.
We are listing it on 10th of March.
Lordship.
May I please, Your Lordship? My Lord, I beg to mention item number 18, my Lord. The last 3 occasions, my Lord, case diary had been called for. Today it is also not available, my Lord. And I am not also on it.
Case diary is not available.
item number 18, my lord, sitting office.
He is saying that in 3 occasions,
Search sheet submitted, my lord, as per my instruction in this case. The search sheet submitted on 7/12/20.
you are not on interim.
No, my Lord, I am not on it.
What is this CS number?
Yes, right. CS number, my lord, 243/2025, dated 7/12/2025.
Okay. It is already charged.
My Lord.
Part Mr. Air Bryant, Internal Counsel, the petition, also part Mr. Internal petition, people bring on the proceeding. Case was fixed for case diary, but it is submitted by Mr. Bottom. The case has already been charged. Hide CS number 243 of 2023, dated 7/12. So you appear before the
My Lord, I will appear, my Lord, till my appearance. May I pray for some protection?
Sorry. If any adverse order is there, then definitely you can come before this court.
Fine.
But at this stage, we can.
Obliged.
May I please, Your Honor?
Interim readable 15 days.
May I
Yes.
please, Your Honor? In item 14, we have filed an additional
40.
affidavit. Yes, Lordship, 14:14. We have filed an
1-4.
Yes, Lordship. We have filed an additional affidavit that means finally called for.
In 1-4.
Yes, Lordship.
1-4 at the additional. Okay.
Obliged, Lordship.
With the consent of the other side, I beg to mention item number 21. for adjournment.
May please your lordship. Your lordship, I appear for the appellant's hearing. Your lordship may kindly fix a date. Item number 31.
Was you are for the respondent.
Respondent number.
Consent
Yes.
of the other sector. It's what it make stating convenience the party is not matter. Due to the influence of the case counsel could not be appear before. Yesterday also adjournment slip was there.
Yes, Lord.
Adjournment slip was there.
Yes, Lord.
You want fixed date. It is matter of 2024.
Sure, lordship.
How we can fix a date? So
26.
definitely
It can be on 26th of the
20
26th.
of
of this month.
Yes.
17th of March at best. 26 is already full.
Much obliged.
Obliged.
Item number 23. It was called for, but it is not available.
In this
CDF
case, substitute submitted.
Charges submit. You were on interim date?
No, in till appearance,
Sorry. What is the CS number?
CS number 1/26 dated 27/1/26.
So you are ऐसे ना लिखी सर आप लिखी the 7/1/26 CS 1 only. Then direction depot within it to appear before the learned trial with an application which may be considered. So you just appear before the learned trial court. If any adverse order is there, definitely you can come. At this stage, we cannot pass any order in.
Item number 24, ma'am. I have CD notice.
20?
24. I'm not on interim, Lord. So
24 minutes CD not.
what that may be given. Lord. There is no interim.
Issue reminder. Short date now, see, short date, we don't have such short date, but we'll try, yes, with the point.
Next week.
It's not possible.
2 March
2 March will be too long for him.
Too long, my lord, because there is no interim.
on 25th then.
25th? 25th.
Deeply obliged.
May I please your lordship? I may be allowed to withdraw the criminal petition, lordship, with the liberty to file a fresh, lordship. There are some factual errors in this petition, so I may be allowed to withdraw the.
Yes, Portaco, they also seeking a liberty to file a bill. What error
What?
is? What kind of error was there?
Lordship, I'm not aware, but there are some factual errors, lordship.
In that case, we have to hear the matter. Otherwise, we are not in a position because every petition cannot be allowed to be, withdrawal with a liberty to file a fresh unless there is a reason. I don't know what is the reason. They also, have you, in that case, you have filed a petition also seeking the ground on which ground you are withdrawing the petition with a liberty to file a simple withdrawal, simple verbal submission will not.
Yes.
So you just file a petition in form of additional affidavit that you are going to withdraw this one, and also bring the reasons why you are going to withdraw and what are the reasons we have to see. Otherwise, the case that we allowed to withdraw and liberty to file. In that case, we need some reasons.
Yeah.
So you file an additional affidavit. We'll see to it if it can take case for allowing you to a liberty can be given. Then in that. You are a MS.
Yes, Yasmin.
MS S Yasmin, the learned counsel for the petition, and also heard Mr. Peabody. It is submitted by MS Yasmin that by instructions of client she wants to withdraw the same with a liberty to file afresh. She verbally submitted. There are some factual defects, but without any. But in that regard, they have not filed any affidavit. In view of this, petitioner is hereby directed to file an additional affidavit bringing the grounds for their withdrawal. List the matter accordingly. After 1 week, we are listing. We are not fixing any date here.
Next week, Lordship.
Date, you want date?
Yes, yes.
Date in case to date, it will be a longer date. Yes. 10th of March.
Lordship, before that, Lordship. February,
That's why
March.
I'm saying that within 1 week, we are
Okay,
not
Lordship.
fixing any date. List after 1 week as on a date we fix the date. Because 1 week, it may be listed before any other court.
Yes, okay.
Maybe, because we are not in a position to list it matter till next week.
Much obliged, Lordship.
May I please the lordship? I have withdrawn the criminal petition with the liberty to file a fresh lord.
Same order will be here.
Lordship, due to non-annex of the police report and respondent opposite party complaint has not been annexed there with lordship. That is why.
Due to
Due to non-annex of the police report, lordship, as well as not annex the complaint of the respondent party, lordship.
but through an additional affidavit, what is the harm? Through an additional affidavit being those
And
documents-
also, lordship, a minor correction of there an application section 528 read with section 430 is not annexed there with lordship.
don't know. For that reason, you can file an additional affidavit, bring those documents, we'll accept it. No issue. We're not forbidding you. I mean, through an additional affidavit, you can bring all this.
Earlier occasion, lordship matter came up before this court. Honorable Justice, lordship said that this petition is not maintainable and application is already incorrect, lordship. Section. That is why lordship I have withdrawn the matter and the liberty to file a fresh lord. Now look at the document of
Where it is reflected in the order, which order?
only for lordship verbally said to me, lordship.
Acha. You file under 528.
528 lordship read with section 438 along with lordship 442 maybe lordship. But I have written the 528 lordship 442 lordship an application lord.
It ought to have been 438.
438 lordship is also
Well, he has probably wrongly mentioned the sections, as per his contention, and he has also not annexed search sheet and one
not such a police report
police
lordship
report.
and also complaint which has been filed before the executive magistrate lord.
Additionally,
Yeah, Mr.
PK Gogoi lord.
Mr. P.K. Gogoi, the learned counsel. Also, Mr. P. Bott, the learned additional PK. And it is submitted by Mr. Gogoi that due to some formal defects in mentioning the sections in the post title of the petition, he wants to withdraw the same with a liberty to file afresh. And that he is submitted that some 2 documents which could not be annexed at the time of filing criminal petition. It submitted that the application has been filed under section 528 with section 442 of BNS, which ought to have been BNSS, which ought to have been filed under section 528 read with section 438 of BNSS. Mr. Waterford, there is no objection to that. Considering this submission made by learned counsel petition, prayer for withdrawal of the petition with a liberty to file afresh is hereby allowed. Criminal petition accordingly disposed.
High level lord.
may I please? 483 application, Lord.
FIR is at page 14, Lordship. It's a long FIR, Lordship. The petitioner is not an FIR name accused person, Lordship. Allegation is that, Lordship, on 12/1/2026, a mob attack took place at Daranda 6 Mile, Lordship. Basically between the two political rivalry parties group, Lordship. In the FIR, Lordship, 7 accused name has been mentioned, Lordship. I am not the name accused person, Lordship, but my brother name is there, Lord. This Brighty, Ashikali Brighty, Lordship. Incident took place, Lordship, on 12/1/2026, Lordship. And since 9/1/2026, Lordship, I was in my native village, Lordship, my grandfather house from 9/11 at Mukalma, Lordship. Police tried to apprehend this Ashikali, Lordship, and went there for search at Mukalma. They didn't find the Brighty and take up me, Lordship, and taken into custody, Lordship. And since then, Lordship, on 15/1, Lordship, I am behind the bar, Lordship, till date 29 days, Lordship. I am neither involved in any political party, not related to my brother activities, Lordship. Police only failed to apprehend the original accused person, Lordship, in this case, and try to take the allegation on me, Lordship, because I was on that particular time available at Mukalma in my grandfather's house. I am no way connected, Lordship. Neither I am
Incident
the
took place where?
Lordship.
Incident took place at Mukalma.
No, Lordship. At 6 Mile Daranda, Lord. At Gauhati, Lord.
The grounds of arrest is 16B, my lord. First ground, my lord. During the course of investigation, it has come to light that you lead the gang in attacking Krishanu Bora, causing him serious injuries. So he is the person, he is leading the entire, my lord, gang at the time of commission of the offense.
If it is correct, Lordship, a basic question arises, Lordship. If I was leading this particular gang, that the complainant could have my name mentioned in the FIR itself, Lordship. Why my name was not mentioned in the FIR, Lordship, out of 7 accused persons? Because they later on charged me and tried to frame charge against me, Lordship. Because they failed to apprehend the original accused person till date, they failed to arrest any other accused person. Even this honorable court granted anticipatory bail to the main accused person, Lordship. This is one of the Ashikali, Lordship. The anticipatory bail.
During investigation, my lord, his name comes to light, my lord. That he is the person. It
Police
is not
just trying to
required.
cover up the story,
It
Lordship.
is
on
not
the
required to
political
mention everyone's
rivalry
name,
groups.
the FIR, my lord. FIR is simply a first information report, my lord. It is not required to my lord, specifically mention the name of all the accused persons. During investigation, my lord, the involvement of he is the prime accused, that comes to light that he actually the person, my lord, leads the entire gang in attacking the.
Okay.
Whatever,
Calling
Lordship,
for the
the
case.
already 29 days, Lordship. I am behind the
Try to accommodate you with a short date as such we don't have. From where it has to come?
My lord,
Dispute, Lordship.
dispute.
Twenty-six two.
Lordship, prior to that, on Wednesday, possible, Lord.
Which Wednesday? This?
Next, Lord.
No. Next Wednesday, parini.
It's from Dispute, Lordship. He is
Next Wednesday, can it be? Very. What
I will try, my
what is the date? Next Wednesday.
18.
18. Problem.
May I please your honest? In this matter, another similar matter arising out of the same PS has already been disposed by Honorable Justice Mr. Pranjal Das. Therefore, the matter may kindly come up before the appropriate bench. Also, Lordship, there is a humble request, if at all possible, kindly the matter may be fixed on Tuesday, coming Tuesday.
It has been informed from bench, in fact.
I'm sorry.
Concerned bench.
Yes,
That
Lordship.
as the Justice Das is now in DV. So unless any matter rejected by him, then only it will go to him. Otherwise, maybe by this court or by the court of Justice Vijay Saikya, because otherwise he is taking the division bench. So in that case, so that was also an AB.
Yes, Lordship. AB.
আগতেতো কিন্তু যোনে এটা এফআইআৰ
He rejected.
দিছিলে তেওঁলোকে নিয়মবিলাক কিয় ওলাইছে, এখন এফআইআৰ চবে একে বুলি কৈ আছে। সেইটো কৰিব দৰকাৰ হ'ল, তেওঁ এনেও চিংলিও বহি আছে তোমাৰ, যেতিয়া আহিব তেতিয়া বহিব। আৰু মানে কথাটো হি ইজ এভেইলেবল হিয়াৰ। এতিয়া কথাটো হৈছে এখন এফআইআৰৰ যেতিয়া বস্তু হয়, এখন এফআইআৰ বস্তু চেম কোৰ্টত বুলি আগতে ওলাই আছিলে কথাটো। But we cannot give any date whenever he will be available, because in every day most probably single bench is not constituted, as he is taking the division bench now. So bench available,
Yes,
availability.
Registry will fix the date.
In that case, bench will be constituted. In fact, pardon, Miss Ridas,
P. Bora, Lordship.
sorry, P. Bora, Delaney Council Petition. Mr. P. Bora, Delaney Petition, people bring on. Considering the submission made by Ms. Bora, let the matter be listed for the appropriate bench, considering the availability of the said bench. Registry will be. Okay.
Obliged, Lordship.
May I please, Lord?
Yes.
This is bail application 482 of BNSSU, my Lord. It is says, my Lord, four accused person. Accused petitioner, one is the husband of the alleged victim, 2 and 3, 2 is the father-in-law of alleged victim, 3 is the mother-in-law of alleged victim, and 4 is near relative, Your Honor. FIR in case number 14, my Lord, sorry, 16, my Lord. And translate to be here on. Edit of particular FIR, Your Honor, particular. সন্মানপূৰ্বক মিনিট নিবেদন এই যে আজি 14 বছৰ আগতে তলত উল্লেখ কৰা আসামীৰ লগত ভণ্টি মিছ জাহানাৰা বেগমক সামাজিকভাৱে বিয়া দিয়া হৈছিল। বিয়াৰ পিছত মানসিক শাৰীৰিক নিৰ্যাতন চলাই প্ৰহাৰ কৰি আহিছে। মোৰ ভণ্টিৰ ল'ৰা ছোৱালী নাই, ল'ৰা ছোৱালী নোহোৱাৰ বাবে নানান ধৰণৰ অত্যাচাৰ চলাই মাৰপিট কৰি থাকে। ইংৰাজী 25-26 তাৰিখে ৰাতি প্ৰায় 9:10 বজাত 1 নম্বৰ 2 নম্বৰ 3 আৰু 4 নম্বৰ আসামী ভণ্টিক হত্যা কৰাৰ উদ্দেশ্যে হাই কাজিয়াৰ সৃষ্টি কৰে আৰু অশ্লীল ভাষাৰে গালি গালাজ পাৰি ডিঙিত চেপা মাৰি ধৰে আৰু শৰীৰৰ বিভিন্ন অংশত আঘাত কৰে আৰু ঘৰৰ দৰ্জা বন্ধ কৰি আবদ্ধ কৰি ৰাখে। তেতিয়া পুলিচে গৈ 1 নম্বৰ 2 নম্বৰ 3 নং আসামীৰ ঘৰৰ পৰা ভণ্টিক উদ্ধাৰ কৰি প্ৰাণ ৰক্ষা কৰে আৰু বৰ্তমানে ভণ্টি মংগলদৈ চিভিল হস্পিটেলত ভৰ্তি কৰাই চিকিৎসা কৰি থকা হৈছে। This is the content of FIR, my Lord. It is a case of simple hurt, my Lord. The police registered the case under section 1091 of BNSU, my Lord. So my humble submission before my Lord Chief that CD and injury report call for. In the meantime, all the accused persons remain on interim previous bail, my Lord.
At this stage, how he can say that this is a case of simple hurt because victim is still under treatment at the hospital, my Lord. So only, my Lord, after getting that injury report and her statement only, my Lord.
Petitioner number 2 and 3, old as a person, my Lord. Petitioner number 2, there is Ismail Ali, who is about 66, and petitioner number 3, 61 year, my Lord. Considering the
They are more dangerous.
yes.
Yes.
Considering age, my Lord, they are on at least 2 and 3. Petition number 2 and 3 allowed to remain on an interim PRS, my Lord. And in the meantime, injury report plus CD.
At any short date, otherwise without getting injury report and her statement,
This 2 and 3 allowed.
is still undergoing treatment, my Lord. Maybe, my Lord, now case is registered also under 109 is also there. And now what happened to the victim, that also, my Lord.
Cannot be.
Bare procedural of FIR, my lord, there is, I think there is no any essential ingredient of 1091, my lord. Thereby, I pray before my lord, please allow 2 and 3 to remain on previous bill till disposal of case or disposal of case diary. Only 2 and 3. Old aged person, health issue also there.
Mr. N.K. Hello? You are
NK.
Mr.
And
Mr. N.K. Pivot Learning Petition 50 application. It's an application section made by considering the age of the petition number 2 and 3. They are allowed to remain on an interim bill. Interim period is bill till receipt of case diary. However, the prayer for respondent petitioner number 1 and 4 is not considered. Prayer for interim period is bill for respondent number 1 and 4 is considered. If their city CS pen can be
My lord. 5th of March.
5-3. We're listing it on 5 and 2 and 3 will be under interim.
May it please, your lord. My lord, it is an anticipated bail application, my lord, under 482 of the BNSS, my lord. Yeah, my lord, the case has been registered under 108, my lord. That earlier, my lord, 306, my lord. Unfortunate incident, my lord. Case 11 is the FIR, my lord. The father of the deceased, my lord, unfortunate lady, he has lost this FIR, my lord. And if the lordship goes to the FIR, my lord, lordship find that she was married to the accused number 1, my lord. That Montu Das, my lord, around 9 years back. And they were having a child, male child. Now, my lord, that one line, my lord, that some relationship, my lord, with that accused number 2, who is before our lordship, my lord. So, my lord, because of that, she was being mentally and physically harassed, tortured for the last 3 years by her husband, my lord. That is number 1, my lord. But last line, it says on last so and so in the evening, so and so, my daughter so and so committed so and so by hanging house at the veranda of the house of accused number 1 in her husband's house, my lord, due to not tolerating the inhuman torture of both the accused persons, my lord. That one line is there. Now here, my lord, kindly see, my lord, 9 years of marriage with the accused number 1, my lord. And my lord, our case is that he is a neighbor, my lord. And the accused number 1, my lord, he, my lord, has some, my lord, that problem, my lord, alcohol, my lord. So he takes substance also. So local people sometimes intervenes in their, my lord, quarrel, my lord. And it is a fact, my lord, some relationship like platonic, my lord, not that illicit, my lord, not that, my lord. Some platonic relationship with her, it is a possibly, it is also a fact. And one rumor was also spread, my lord, because that area, my lord, that village area, my lord, people say might be she is having some relationship, my lord, with the present petition. But possibly, my lord, under no stress of imagination, my lord, that 108 possibly cannot be attributed to him, my lord, because he is the outsider, my lord. So, and mental and physical harassment by the husband, maybe because of the reason, maybe him, my lord, that he husband suspect that something is there, my lord. But that reason possibly, my lord, that section 45, my lord, that abetment, my lord. Possibly within that definition, that abetment possibly won't come in this case, my lord. My humble prayer, my lord, lordship may call for the case diary, and in the meantime, my lord, lordship may protect him in the interim, my lord.
Well, there is specific allegation in the FIR, the one due to not tolerating the inhuman torture of both the accused persons, not only one, my lord. Otherwise, my lord, regarding the whether there is any materials regarding for attacking that, my lord, provision of section 108 or not, and that will, my lord, reflect only after receipt of the CD, my lord. But now from the, my lord, it is specifically, my lord, stated that because of the inhuman torture, maybe, my lord, she has some relationship with the accused number 2 for that, my lord, and how he is involved in for that reason, how she was tortured, my lord.
But even I assume, my lord, that I had a relationship with her, my lord. Assuming but not admitting, my lord, whether it will be abetment, my lord. kindly see, my lord, because specific allegations she was staying with her husband, my lord. Husband was torturing her, my lord. Why? Even if I admit that because of me, my lord. So whether it will be 108, my lord, how can it be? Kindly let my friend read section 45, my lord, of the act, my lord. Because section 48 possibly won't be attracted, my lord. Now the husband is not before lordship. Somebody else, he's a married person. And lordship may kindly have a look at page 4, para 8, my lord. I'm not submitting all this. Lordship may kindly have a look once, my lord, our Abetment, my lord. Even if there is a name in the suicide note, my lord, lordship knows, my lord, there is continuous harassment. My mens rea must be there. My intent must be there. My instigation must be there to force her to commit suicide, my lord. She was unhappy with her husband, my lord. He was an alcoholic, my lord. He takes drugs, substance abuser, my lord. I intervene sometime, my lord. And absolutely, my lord, no case under possibly, my lord, subject to what is there in the case diary, my lord.
Now only the FIR is with us. Maybe, my lord, knowing fully well about the, my lord, alcoholic condition of the accused number 1, he, my lord, knowing fully well everything, established, my lord, relationship with the, my lord, victim, my lord, and thereby instigating, my lord, the accused number 1, my lord, for, my lord, therefore he caused, my lord, mental torture. Maybe, my lord, everything.
My lord, kindly see, my lord, here, my lord,
Now
it may be a moral wrong, my lord. It may be a moral wrong. If I assume, my lord, something is there, my lord, maybe a moral wrong. How can be criminal act be attributed? That to, my lord, 108306, my lord. I live separately. I have my wife. I have my children, my lord. I stay separately. Some relationship may have cropped up. Although we are denying it, we say it is a platonic relationship, my lord. I leave it to your lordship, my lord. Possibly it's a lordship, that discretion may be, my lord,
Because,
exercise.
my lord, now at this point of time, only the FIR and the contents is, my lord, with us. So only, my lord, after receipt of the CD, my lord, after perusing the entire materials and the facts and the circumstances, my lord, that can only be from those materials, my lord, it can be seen whether my lord, section 45 of the DNS ingredients is there or not. The CD will reveal everything. My lord.
I also not asking for absolute bail, my lord. CD will reveal, my lord. In the meantime,
In
lordship
the
may
meantime,
protect
my
him.
lord, considering the, my lord, because ultimately she committed suicide. No, I'm not. Ultimately, she, my lord, ultimately, my lord, death caused to the this, my lord, victim. My. So,
Is committed suicide.
at this point of time, I cannot say whether this is a case of suicide or not.
Case has been registered at 108. What you are submitting?
Oh, sorry, ma'am.
Be fair.
Yes.
Part each of the Delaney counsel for the part Mr.
Yes, registered under 108. Ultimately, he may be the main.
This is an application under section 7. Is submitted by Mr. Chaudhary that it is an ex- Yes. No way connected to the extras. It may be a fact that the victim may have some relationship with the accused petitioner who is named as an accused number. But from the statement made in the FI itself, it is seen that there can be any reason for the victim to commit suicide only for the relationship with the present. If whether is accordingly submitted, the city will may reveal the actual fact of the case. But as per the information, the victim was not with her husband of the case who used to torture her. And being but the present petitioner is ready and willing to extend his cooperation in the further investigation of this case if it is granted with the privilege of interim pleas. Next, Mr. Bott, done a petition and be treated in this regard that if from the FI cannot be held that the present accused petitioner is not liable for the said offense. But there is a specific statement that the due to as the petitioner could not as the victim could not tolerate the inhuman torture of both the accused person, she committed suicide. Mr. Waterford further submitted that CD may be called to know the actual fact of the case, and without result, it is not possible. It is not proper. No. Call for the cases to come. Next, hearing the submission made by learning completing statement within the FIR. I find it a bit case to extend the privilege of interim period of stay to the present petition till receipt of the case diary. You will be under interim petition.
My lord,
You will be under interim petition.
highly obliged, my lord.
9th of March.
Much obliged, my lord. Highly obliged. I'll appear, my lord, in the meantime.
Yes, yes. Within 7 days you have to.
My lord, highly obliged.
May I please, Lordship? But the previous bail application, Lordship, I am not the name accused of the affair, Lord. Lordship will find the affair at page 22.
Page 22.
Page 22, Lordship. Lordship got it?
Yes.
Affair dated 22 November 2025, Lordship. Complainant, MS Saina Traders. Lordship, a proprietorship firm, proprietor, Sri Sanjay Kumar is the complainant. Lordship. Now, Lordship, complaint is lodged basically, Lordship. One name accused, Lordship, is Sanjay Kumar Sharma. Sarkar, sorry, Lord. He is the authorized person of the complainant, Lord. Lordship, will have a look.
Authorized person of the
Lordship.
company. No,
Proprietorship
who is
firm.
the authorized person?
Name accused of the affair, Lord. I am a bank employee, Lordship. Lordship,
Acha, Sanjay Kumar Sharma.
Sarkar,
Sorry.
Lord. May I read it, Lordship, the affair?
Because FIR is also lost by one Sanjay Kumar.
Sanjay Kumar. So with due respect and humble submission, I would like to intimate you that I am the proprietor of MS Saina Traders, Bangladesh, Assam. For initiating legal proceedings, I have executed an authority letter in favor of Mr. Sanjay Kumar Sarkar to initiate legal proceedings. Executed authority letter to Sanjay Kumar Sarkar by the present informant. By virtue of the said authority letter, Mr. Sanjay Kumar Sarkar initiated a writ petition before the Honorable Gauhati High Court by case number so-and-so against the state of Assam so-and-so. After hearing both the sides, the Gauhati High Court, Honorable Gauhati High Court was graciously pleased to pass an order that is so-and-so directing the respondents to refund an amount of rupees 1,61,10,097 rupees. Only in favor of the so-and-so. In spite of the state order to so-and-so passed by the Honorable Gauhati High Court, the respondents failed to refund the amount to the complainant, for which the complainant again initiated the contempt proceeding against the said respondent. Lastly, on so-and-so, the Honorable Gauhati was pleased to pass an order and listed the case in so-and-so. He is the authorized person, legal authorized person. The name is of fire. It is worthwhile to mention here that I have instructed Mr. Sanjay Kumar Sarkar to deposit the refunded amount in favor of either of the account of my proprietorship firm, White number so-and-so, lying with the State Bank of India, so-and-so, or in the accounts of White HC number so-and-so, lying with the Axis Bank, Beltola branch, Gauhati, in the name of Saina Traders. Next, please, Lordship. Meanwhile, from the reliable source, I come to know that the below name accused person, along with the bank officials, that is the application, and some other persons with ulterior motive have forged my signature using my credentials without my consent and created an account aligned with a Northeast Small Finance Bank white accounts for so-and-so, the Kailaspur, Rani, place so-and-so, Rani, Kailaspur. The above mentioned first account is neither my personal bank account number nor the bank account number of my aforesaid proprietorship firm, but the below name accused person, Lord. Again, Lord Severa, has deposited and used the aforesaid first account with malevolent intentions and ulterior motive to defraud me, has credited the refunded amount by misleading the authority concerned to commercial tax. That is the accusation, Lord. The accusation against me is that he was not there, Lord. As admittedly, Lord, the informant was not there while the accounts are opening. That is true, Lord. Being the authorized person, Lord, Mr. Sanjay Kumar Sarkar went to the bank and opened an account in the name of the present informant, Lord.
Where it is 6. He is denying.
That is the factual aspect, Lord.
No. As per the contents of the affair, he is denying that he has.
Yes. But he has a good relation with the name accused, Lord. That is the admitted position, Lord. Admitted position. The informant has a good relation, Lord, with the name accused of the house.
Yes, he is authorized.
Yes. But the allegation is that he was not there and he had the signs in the bank documents, Lord. That is the contents of the affair. So far, I have understood, Lord. Date of
Otherwise,
order-
my lord, from the contents of the FIR allegations are saying.
Very serious.
Allegations are because, my lord.
Because as per the
He
order
is
of
the
the
authorized,
court,
he is
that
the
matter
authorized
was
person.
refunded. Huh?
Yes, well, and the present accused person is authorized person by the complainant to receive all, to do all the legal proceedings before
Yes.
in that regard. And thereafter, my lord, that the entire compensated amount, that is more than rupees, my lord,
1 crore.
1 crore 60 lakhs.
supposed to, my lord, he instructed to, my lord, deposit the entire amount in a particular account, my lord. Thereafter, by using his credential, he opened a, my lord, a separate third account, my lord. And now the, my lord, complainant said that that is not my bank account, my lord. So if that compensation amount of, my lord, 1 crore is deposited in that account, my lord, that is the account of the money of the complainant, then that is a serious offense, my lord. Without his knowledge, my lord,
No,
by
this
taking advantage of his.
petitioner is the bank employee.
Yes,
He-
back of it.
Your petitioner is a bank
Bank
employee. It's a very clear allegation against you that
Yes.
Lordship,
with
account
the
was,
help of the bank
date of
officials,
the
you get
account's
that account
opening,
is
Lordship,
open.
account was open on the in the year of 24.
Huh.
20 October 2024.
Huh.
Lordship, then present petitioner transferred from that branch, Lordship, on 24/12/2024.
Then okay. In
The
the
transaction was
December,
happened.
he got
Transaction was happened, Lordship, in the year of 2025, as alleged, Lordship.
but the
I was
account
not
was
there.
open. Account was open on which date?
2024.
Ah.
I have annexed the transfer order, Lordship.
No. Bank account was open on which day? In 2024.
24.
He was there
October.
only.
October, yes. I am not the complete authority of the bank, Lordship. I am a sales officer, Lordship.
And my lord, what
But
happened
that's
to
why you I don't know then why there is an apprehension.
Lordship, police has already instructed me to
Searching
appear
you.
before the IO. I am ready to appear, Lordship. I am ready to appear,
Well,
Lordship.
otherwise, my lord, what happened to that contempt proceeding? My lord, the informant, complainant
Hmm.
regarding that also there is no information, my lord, because
I have annexed the
suppose if
contempt
he had
order.
opened a third party account, then probably all those things comes to light in that contempt proceeding also, my lord. Because if he has filed the complainant, my lord, informant has.
No. Complainant had filed the contempt proceeding that account has already been the amount has already
Yes,
been deposited
yes.
because by the contemner.
And regarding the present status of that amount, my lord, what
No.
happened to that amount one? So my lord, only CD will reveal the.
So I have annexed the contempt order also, Lordship. The name accused represented the present informant, Lordship, in that contempt question.
No, obviously.
Lordship.
He was authorized.
Yes, sir.
That is not
As
in
per the affair, Lordship, transaction was happened in the year of 2025, Lord. 2025. I was not there, Lordship. Now I am in the
You're
D4,
saying that those transaction was in 2025 only.
Lordship.
Where from you're saying that all transaction was in 2025?
Lordship, after lodging the affair, Lordship, the vigilance cell of the bank, Lordship, wrote a letter to me to submit a written.
You have annexed here?
Yes.
Yes, which page?
Otherwise, there is specific allegation in the present FIR again.
In which page?
Lordship, I will find it at page 24, annex 3. 24. Lordship, to the Vigilance Department, Northeast the Small Finance Bank, expense of involvement in fraud or irregularities. Expense of Lopez Dica, branch at Interim.
It's on 22/10/2024.
Lordship.
Name of MSS Signer Traders.
The account was big and sourced by Mr. Abhijit Bhomik. He used to commute to Gauhati to Kailaspur Rani every day. Abhijit Bhomik visited the customer place pickup and from along with documents while coming to branch from Gauhati and gave me. After racing the branch, he asked to me fill up the form immediately and take the form to head office for activation once completed. Since the account was sourced, pickup branch manager himself, I could not doubt.
But
And it's so.
you're saying that in the year 2025 it had happened.
Yes.
But from the brief of the from the letter it is seen that branch was open on 22/10/2024 itself.
Yes.
not in 25. So your
But-
petitioner was there in this bank at that time.
He was there, but Lordship, he is not a disbursing authority, Lordship.
Now you are saying why you are clicking your stand. Just a
Lord-
while you are saying that he was not there because the entire transaction
At
bank
the time
account,
of
the bank
transaction,
to
he was
bank
not there,
account was
Lordship.
in
At the time of
2025.
transaction,
Now
at
you are
the-
saying he was, yes, obviously he was there. He was in bank
at the
account
time of
at that
the
time.
opening of the account, he was there, Lordship.
Yes.
Just a
Why-
while you are saying that you are not there.
No, at the-
From a bank account
the
was
time
in
of the-
2025.
At the time of transaction, Lordship.
No,
Transaction
no.
happened, Lordship, in the year 2025, Lordship.
What transaction?
One crore was 61 lakhs something, Lordship.
Ah.
This happened in the year
But
2025.
bank account was open on 22/10/2024 itself.
I'm not the branch head, Lordship.
That
I'm a
is
sales
your
officer,
case, but
Lordship.
you are saying that you were not there. Now you are saying that you were there.
No, no, Lordship.
Only schedule you fill, my lord.
Just a while you are saying that
I'm
while
submitting,
the
Lordship, at the
account
time
was
of the
opening,
opening of the account, Lordship, I was there.
now
the
you are
time
saying
of
you were
opening.
there. A bit while you were saying that you were not there because it was ended
No, no.
transaction was in 2025. We are not there.
I'm not
Now
submitting.
you are saying that you were there. Everything was done in the 2024 itself.
I'm saying that, Lord.
No.
In the year
City
2024, I was there, Lordship. Kindly protect me, Lordship.
City call. Giving a short date.
Yes.
A date about Lordship, he has already, once he has appeared before the IU also, Lordship.
When
26.
26 will do or you more shorter date?
Lordship, it is from Polasgari, Lordship.
No, Polasbari is okay.
22, my lord. 20.
22nd of this.
Yes.
Oh, sorry.
20, my lord. 20.
20.
Obliged, Lordship.
May I please, your lordship? My lord, a report may be called for from the Rungya police station, my lord, whether any case is registered or not, because without serving any notice, my lord, police is visiting my house, my lord.
Which police station?
Rungya, my lord.
Rungya.
My lord.
Heard Mr. S. It's sector, the landed council petition, heard Mr. B. It is submitted by Mr. Sector that the police from Rungya PS is searching the present petition. And hence there is an apprehension of his arrest in connection with any case from Rungya police station. In view of this, it is submitted that a report may be called for from Rungya police station as to whether any case has been registered against the present petition in the said station. In view of this, let a report be called for from Rungya police station.
Till then, no action will be taken. my lord.
Sorry, when it can
On 23 to
23. Report be called for the additional people will take this steps. Okay. Thank you.
Okay.
May it please your lordship.
Yes.
Lordship. Here, my lord, the petitioner is the husband, my lord, of the informant, my lord. Page 12 is the FIR. Page 12, my lord.
Yes.
First, my lord, the allegation is my lord, under section 82 to 1152 and 3513 and 109 of the BNSS, my lord. My lord, the main allegation is 82-2, my lord. That I will come, my lord. That is marrying again during the lifetime of husband and wife. Page 12 is the FIR, my lord. My lord, I, so and so, my lord, presently residing at a rented residence at so and so place, my lord. Hereby lodge this complaint against my husband, Mr. So and so, for committing grave and cognizable offense. On 2/2/26, at my above mentioned residence, my husband launched a brutal and sustained assault on me with a clear intention of killing me. He repeatedly punched and violently smashed my head against the wall, causing severe pain, disorientation, and fear of my life. The attack was relentless and targeted at vital parts of my body. Immediately thereafter, he picked up a knife and advanced towards me to stab me, leaving me with no option but to run out of the house to save my life. I firmly believe that I had to escape at the moment he would have killed me. His actions clearly constitute attempt to murder. An attempt after the incident, he threatened to kill me and my family members if I approach the police or sought any legal help, thereby creating a continuing and serious threat to our lives. I further, my lord, this is the main problem. I further state that the accused fraudulently married me by concealing the fact that he was already married twice and has one child of his marriage without any legal separation from them, facts that they came to my knowledge only after our court marriage. Whenever I attempted to lodge complaint after discovering this, he immediately and silenced me, claiming he has connection with senior police officials and my lord, so this is the FIR. Now, my lord, she has stated that I have married my lord, but my lord, Lordship may kindly turn to the affidavit that is shown in 2016, page 14, my lord. Page 14, my lord. Page 14. See 2016, my lord, she has clearly stated in her affidavit that my lord, she knows that I am a married person, my lord. She has married me, my lord. And my lord, the petitioner is a patient of leukemia and blood cancer, my lord.
Why she was swearing this affidavit? For what purpose she was swearing?
My lord, she has she wanted to marry me. Then she wanted some assurance, my lord, that my lord, I am a married. I have told them, but I have no objection if she married.
No. Why she?
In
sworn this
2016,
affidavit?
my lord,
Why she sworn this affidavit?
because I have, my lord, I clearly told her that, my lord, I am a married person. If there would something, you might file a case in 2016, not now, my lord. Now, my lord, 2016, my lord. And my lord, that's why, my lord, she has shown that I have no objection. I will marry you. And moreover, my petitioner is suffering from blood cancer, my lord, since long, my lord. Leukemia patient, my lord. That is starts from page 22, my lord. Page 22, my lord. He has been diagnosed with my lord, blood cancer, my lord. And my lord, moreover, my lord, regarding the heart section, injury section only, my lord, the heart, which is my lord, available section, my lord. Regarding that, my lord, I have given an affidavit, my lord. Petitioner is a patient of my lord. And more, I have stated, my lord, that I have clearly stated what is the petition from the my page 5, paragraph 6, I have categorically stated, my lord, that I will, my lord, reconcile, my lord, and my lord, lead again lead a happy conjugal life, my lord. Page 5, paragraph 6, my lord, if read, my lord. Regarding heart, my lord, it's a bailable section, my lord. Only simple heart is there. Regarding that marrying, she knew, my lord. She knew, my lord, that I am a married person. And my lord, he's a blood cancer, suffering from blood cancer, my lord.
Where is the diagnosis?
My lord, I have Tata Medical Center, my lord, page 22.
No, since page 22, it is there. He was diagnosed as a
diagnosed, my lord, in the top portion, my lord, diagnosed, my lord. It is Mia Milo. It's a blood cancer. I have my lord, found.
Milo.
And my lord, we'll reconcile, my lord. There's some mistakes, my lord, some quarrel at that moment, at the heat of the moment, she has lost his affair, my lord.
Now she is living.
No, my lord, she has gone to her parents. My lord, I have categorically stated, my lord, we'll reconcile the matter definitely, my lord. Okay. And my lord, only, my lord, there was no heart, nothing, my lord. Only, my lord, regarding that heart section 1152, my lord, it's a bailable section, my lord. And
yes.
Your lordship may kindly come to first this affidavit that was shown in the year 2016. So now, my lord, he has annexed a document which was shown in the year 2000. So it will be, my lord, why he is keeping that an affidavit that was shown in the year 2016, my lord, I do not know. And regarding that, my lord, 23, page 23, that is the, my lord, patient evaluation summary. That is the document of 23/10/2015. So still, my lord.
No, blood cancer won't cure. It is a non, it cannot be cured, my lord. But he is under some medication. My lord, now he is better, my lord, but it cannot be totally cured, my lord. And really, husband and only simple heart is there, my lord. No grievous heart, nothing, my lord. So Lordship may protect me, my lord. I have categorically stated in my petition, my lord, that my lord, bona fide desire to reconcile and save the matrimonial bond, my lord. Page 5, paragraph 6.
And your lordship, paragraph 4 of the FIR, I further said the accused fraudulently married me by concealing the fact that he was already married twice and has one child from marriage without any legal separation from them. So not only once, my lord, twice. He has also, my lord, one child by concealing all those facts. At that point of time, he is a patient of, my lord, leukemia, my lord. By
That's why this, I have
yeah, in
annexed
the
the
year
affidavit, but he knows.
2016, in that affidavit regarding his, my lord, medical condition was also not there in the, my lord, affidavit.
My lord,
So all
regarding
these things were concealed. So, my lord, it seems that, my lord, there was genuineness of that affidavit and documents.
my lord, but I have annexed it, my lord, on oath, my lord. My lord, that we never do, my lord, that we have never annexed fake documents, my lord. And I have, but Lordship may kindly see paragraph 6, my lord, of my petition. I categorically stated, my lord, that, my lord, the petitioner begs to state that the petitioner begs that the husband she holds a bona fide desire to reconcile and save the matrimonial bond, my lord.
Yes. Heard Mr. SM of the Iran also petition. Now should be brought for Iran additional PPA. This is an application next by submitted by Mr. Abdullah that representing petition. The victim got married and at the time of the marriage, it was also within the knowledge of the victim that he is a married person. In before the marriage, also she sworn an affidavit in the year 2016, wherein it specifically stated that she has the knowledge that the accused petitioner is a married person. It further submitted it is a case of heart, and there is every possibility of reconciliation between the parties. Also, the petitioner is a patient of leukemia, and he is suffering that regard. Some medical documents are also submitted with petition. However, the petitioner is ready and willing to extend his cooperation for the investigation of this case if it is granted with the privilege of the expert. Next, what would Ilanate additional PP submitted in this regard? That though the affidavit is stated to be sworn by the victim in the year 2015, but from the FI itself, it is seen that he was married. He married twice before their marriage, and there is sufficient allegation of torture in the FIR. Further, he submitted that all the medical documents which were annexed along with the petition seems to be of 2015 to 15, and there is no document to show what is the health condition of the accused petitioner at this stage. Next, in that regard, Mr. Abdullah submitted that the blood cancer is a kind of a disease which cannot be fully cured, and he is still suffering from the said disease. However, and the said disease pushed. But as there is a scope of conciliation, the petitioner may be allowed to be provided with some interim protection at this stage. During this submission made by learning counsel for both sides, and have also produced the petition as well as the annexures filed along with the petition, including the medical and the other documents. Considering the entire facts and circumstances of this case, I find that some interim protection can be provided to the present petitioner till receipt of the case. Okay, you'll be under interim.
I'm deeply obliged, my lord.
Lister 93 COVID.
May I please, your lordship? Lordship, this 482 application is filed against a non-FIR, my lord. Basically, the facts is that on 8/2/2026, some police personnel came to my residence. Fortunately, I was not at home, but then my family members inquired that what is the case about. Then they came to know that some Razia Yasmin had filed, a lady, Razia Yasmin had lodged a complaint before the police. It is a fact and admitted fact that I had a relationship with that lady, my lord. Later on, though she concealed that she had married thrice with another man. Then, my lord, I took some time that I'll have to convince my family members that already she had a married girl. Then she started blackmailing me. And she even went further at page 10, my lord. She have circulated some nude pictures of the petitioner in the social media also, apart from lodging the false complaint before the police, my lord. And the police is searching before me. Even yesterday also, the police came to my residence, my lord. So apprehending arrest, my lord, this petitioner has approached this honorable court. My lord. That is the only case.
No, where is the FIR? You don't know.
No, my lord, but GD entry is there, my lord.
GD entry is there.
Yes. GD entry number is 020 of dated 30/01/2026.
Dated
30/01/2026, my lord. Annex কৰা নাই মানে আমি পোৱা নাছিলো যোৱাকালি পাইছো
in before Abetment police station.
Yes, Abetment police station, my lord. Yesterday I got this GD entry, my lord. So couldn't annex it. Type copy is also there.
Yes, what?
There. Put it.
My lord, on 23rd,
You want any protection?
Yes, my lord, definitely. Police is behind me, my lord. Let the report come on 23rd. Till then, my lord, protection may be given. I will appear before the IO. my lord.
Part Mr. PM declared constitutional report. The done addition PPM. This petition is filed taking clear restraint for the present petition, stating that he has an appeals as the apprehension of filing any FIR against him by one Regina Yasmin. Regina Yasmin is submitted by this part is submitted that it is a fact that the present petitioner has some relationship with said Regina Yasmin. But when he came to know about that, she married thrice before the relationship with the present petitioner. He tried to convince his family member, but in that at that relevant time only, she started blackmailing him and even make some nude photographs of the present petition. Submitted that some interim protection may be granted to the present petitioner till receive police report from station. Next part, Mr. Gauhati petition PP submitted in district that the report may be called for at this stage without providing any interim. Mr. Deka further submitted that he also came to know that one GD entry has already been made. High GD entry number 20/20 dated 30/01/2026 before Obapuri police station. Saying the submission made by students. The present petitioner is hereby, let us say, no coercive action now. How
Yes.
on what basis?
Yes.
Is provided with some interim protection and no coercive action shall be taken against the present petitioner till receipt of the report from the concerned police station. Accordingly, a report be called for from the Obapuri police station, Bongaigaon, as to whether any case has been registered against the present petitioner in the city. 23. You are saying not 23?
No, 6-3, my lord.
6-3. 6-3. You will be under interim.
Much obliged, my lord.
My plea.
Yes.
Herein also, your lordship, I am out of apprehension, your lordship, this petition has been filed. Because in para number 6 of my petition, your lordship, I have mentioned some dates, your lordship.
Para number 6.
6 plus 5. 106 para 5. 106, 08, 11, and 20. These are the dates, your lordship. The police frequently visiting my house, your lordship. And the petition number 1, he is a man, 82 years old man. Although there is no case, your lordship.
No, why?
No,
Why the
The case, we have not found any case registered against the petitioner, your lordship.
No. Yes, I can understand because in the earlier case I heard, I think that was the case. There are some
Yes.
point for apprehension.
Yes,
What is your apprehension?
My apprehension is that, your lordship, the 1/5/2026, there was some dispute, your lordship, the petitioners and some others. And regarding that, a affair was lost by the petitioners. That affair has not been registered till now, your lordship. Instead of registering our affair, the police is running behind the petitioner, your lordship. And para 6, these are the dates on that date the police visited the house of the petitioner. At this stage, your lordship, I am seeking only some protection may be given, your lordship, and my friend will take instruction from the. Because the petition number 1, he is 82 years old man, your.
17th, my lord, I can get the Tuesday.
17 he is bringing the report. In that case, heard Mr. A.M. Kant and heard should be what 7 can it be given?
17th March, no?
Considering the submission made by land conservation, the landed additional PP is hereby asked to your report from the Kolkasia police station, Borpeta, as to whether any case has been registered against these 3 petitioners in the said police station. List the matter accordingly on 18-2 we are listing.
Public.
Here the scan copy receipt.
Herein, your lordship, the petitioner, he is in custody for 698 days, your lordship.
698 days.
98 days.
Yes.
And he is the driver where from the Ellis contraband was recovered.
It would No motor.
698, 698.
I'm fine, but it is a special case.
Yes, especially.
Why it is listed before this court? Is there any reason for this? It should be
Special-
listed. Be listed before this court.
Any case.
Appropriate bench. Yes. Tomorrow, okay. List the matter before the appropriate bench.
Can be on Monday.
Monday will do. Monday is 16th. Monday 16th. Oh, 16th. Before appropriate bench. 16th, the registry will do it. Okay.
So,
Hold on.
For a good Tomorrow, TPS. সুধি আছো সেইকাৰণে ৰিজন আছে নেকি মই ক'ত শুনিব লাগিব নেকি এবাৰ পৰা ডিছপ'জ অফ হ'লে কথা নাই সেইটোতো
11 minor in the last occasion also they are absent.
You as well. Last occasion also.
Also they are absent.
Yes, they were.
They are also
Otherwise, since when they are in custody?
minor they are in they are
Or they are in interim?
granted minor on interim granted on minor 9/12
Yes.
and arrested on 28/11.
Interim was it is a otherwise charge sheeted case. Why interim was there?
Too much granted.
Case for interim. Compromising the case. Call for the can this year comprising the case. So, what order we have? Let us wait for another. Continuation of the reminder was not there in the earlier order.
Minor.
This it is not continuing.
Minor. In the
It's
last
not-
occasion also it was not
It's
continued.
not continuing. We simply make a list. None appears on the petition, hard distribution. Scan
here-
copy
this
is
here
received,
is-
scan copy of this year has already been received. List the matter accordingly on. Package 9/3.
Minor.
Will probably valueless. He thought that he are already on bail and
Minor,
no need to
minor,
appear
yes.
before this.
Charge sheet submit.
Charge is submitted.
Charge sheet submit.
Since where are you in custody?
My lord, for the 74 days.
7.
My lord, my lord, though the section 179, my lord, inserted in this case, my lord. So far the position is concerned that I am admitting, my lord. By the punishment prescribed section, punishment for 7 years. Mandatory period is 60 days, my lord. So section 179 is concerned, it is only applicable in this case, my lord. There is no,
Now we are not in a position to see all these things. A case has already been
Minor. Charge sheet.
Mr. FK and
the charge sheet submitted means, my lord, investigation is completed.
That means further custodial detention may not be necessary, my lord. That
No,
means
we are not in a position to pass any order. Let the trial court be passed, and if there is any adverse order is there, that definitely you can come to this court. So and also heard Mr. B. Sharma regarding the additional rights. City not received, however, it is submitted by Mr. Sharma. That case has already been transited. Yes, by CS
It's
number
my charge number 30, my lord, 3025, dated 30/1/26.
301 20.
26.
Then CS number 30/2026.
Oh. That perhaps it is 30/26. I'll verify. But
No, you
in
should
our
verify.
mind,
Will keep for time being or what?
tomorrow.
Tomorrow?
Maybe
Because there should not be any
typing mistake also.
maybe typing, maybe
Normally, I think 403.
403.
okay, listing it tomorrow.
Also, question not looking for.
Not a good way.
His petitioner's name is Baharul.
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 It is for Baharul only.
Fine.
I'll
It
get this.
is North Lakhimpur PS case number 403 of 20.
Then it's okay, but there may be some. It's
Minor
clarify
typing
it.
mistake.
Wait,
I will verify. ma'am.
আমি so and so করো and it is seen that though the case has already been transited as per submission made by Mr. Sharma, but there is needs some clarification in the
That's it now.
in respect of the CS number. In view of this, the learned additional PP is hereby asked to clarify the matter. Let the matter be accordingly listed on Kalikitari.
Tomorrow one, 13 month.
Just make it clear.
Minor.
Problem.
May I finish, Lordship?
Yes.
I have gone to Lordship. There is one 164 Lordship. From that she have implicated that first of all they have beaten the neck, then he fell down, push is there, and the neighbors also said that they have not mentioned about the assault, but about the push. That Supur Ali and the other one petitioner that pushed the deceased Lordship, and he fell down and immediately there was bleeding from his nose, and he died on the spot.
Lordship, you go to the record in page
164 Lordship. I have typed it.
sketch map, page number 18. Page number 18 is there is the dead body is found in the in case record, page number 18, annexure 1. This crystal clear that the dead body was found in the inside the gate of this Abdul Quddus Chaudhary, who is already examined as PW2. And he already in his declared in cross examination, Abul Hasim was lying alone on the ground inside my land. The ground where Abul Hasim was lying on the not concreted. This is when thing is there, my lord. And he was a vital witness because the dead body is found in their house. Or it's a, I think this one a case of the heart attack only, not the any murder. Or already 166 days they was already in conviction mind, in custody.
I will tell her. They have also stated that there was the altercation, there was a quarrel. Then this Supurali and his wife pushed him. While there was a quarrel, he went cry. Then they, after hearing that, they came. Because they have seen that he was pushed. He fell down. And
No any eyewitnesses, my lord.
already this one examined. There's in my under my boundary that dead body was found. There is no one is present in there.
Immediately
He was
they
already
have
examined in
located
cross-examination. Which one who filed the FIR, he was also examined already. But this one, where the dead body is
was
found.
inside your campus.
Yes. This
Whereas then
sketchmap.
you committed murder.
Yes.
The dead body was inside your campus.
Yeah, no,
Then
not
it's
my
okay.
campus. No, Abdul Quddus
Whose-
campus
whose
is PW2. No, already he examined. He already defended Abdul Hasim was lying alone on the ground inside my land. In cross-examination first line, my lord.
In 164, she has taken, he was hit. That was reflected in the corroboration of the medical affidavit. That there is a confusion. in it.
My lord, we have three minor children. Already once my one younger daughter was already raped by the son of this deceased. Only for the cross connection, they filed this petition actually FIR. No incident was happened like in the narrated in the FIR. One minor children with me only in my custody and two others in the neighbor's house. Still they were not protected in. If any conditions in my lord, if you allow the one bail, then we will a person regularly present in the court. This is already he completed both of them 166 days.
Part MSB the redundant conflict petition. And also part MSA the redundant.
I'm MD Mindi, not
Oh, sorry,
colleague.
MD. Redundant conflict petition. SAB redundant additional PPF. It's an application. It is submitted by an scanned copy of the teacher has already been received. It is submitted by MS Methi that represent to whose petitioners are opted any such office as a resident. 40 whose petitioners are behind the bar since 28/8/2020. This has already been charged. 2 PWs are already been examined by the prosecution, including lead. She further submitted that the entire incident happened recorded, and the person only died only due to heart attack and not for the any assault by the present petitioners. Rather, who committed rape on you?
Baharul Islam, the son of the deceased.
Baharul Islam. He died only.
No, Baharul Islam, not that deceased son. The son of Abdul Hasim.
This is name of the deceased is
Abdul Hasim.
Rather, the son of the deceased Baharul had committed rape on their minor, for which case is still pending against him. In that context, while in place where the unfortunate incident took place, they have not committed such offense as a lesson. For the accused petitioners are the permanent resident of their state, and they will appear before the learned trial court below as and when the date is fixed. MS Begum, the learned petitioner PP, submitted in history that there are two witnesses have been examined. There are several eyewitnesses to the case of the prosecution, and from the statement made by the witnesses under section 180 and 183 BNSS, it reveals that the accused petitioners are very much involved in LS. Right. In the LS, and hence she raised objection and submitted that till the recording of evidence of the eyewitnesses are completed, the prayer may not be considered at this stage. Hearing the submission made by the and considering the matters in the case record as well as the case diary and other aspects of the case, I find that further custodial detention may not be required for the purpose of trial. Accordingly, I find it a fit case to extend the privilege of bail to both the petitioners. To which case here really? This is, in which district this case is?
Okay.
Sessions is there?
Sessions 5125.
No, it is before
Additional
the
session
session
just
judge or
number 1.
additional?
Additional session just number 1.
Or it to dissatisfaction of additional session judge. Okay, you are granted bail.
Highly obliged, highly obliged.
Right, please, Your Lordship. Item 14, my lord, regular bail application, my lord. FIR, Your Lordship will find at page 11, my lord. Earlier, my lord, some other similarly situated person, my lord, has approached this honorable court, my lord. And considering their, my lord, ensuring, my lord, examination, my lord, interim was granted, my lord. Page 11, my lord, may I read, my lord. With due respect, I would like to inform you that yesterday, that is on 30/12/2025, the fight which occurred in Amlapati, Golaghat, during which the aforementioned group of accused individuals were physically assaulting Advocate Durga Jaiswal. Since the fight was happening in front of her house, my husband went to stop the fight. My husband's name was Minmoy Hazarika. Unfortunately, the aforementioned gang was so violent that they struck my husband on the road with a wooden baton, causing him to collapse on the spot and also beat him on various parts of his body. Consequently, although he was admitted to the hospital, he could not be survived. He took his last breath at the Jorhat Medical College. It is also heard that another person lost his life. How can a person be killed like this without any fault for which there should be a proper investigation into the matter, and that the 20 to 25% goon squad be apprehended and given strict legal punishment so that no other woman is widowed in future. Please grant me justice, my lord. Accordingly, this case has been registered, my lord. And the petitioner, my lord, actually, my lord, he, my lord, went to the spot, my lord, after the incident has taken place, my lord. Some of his, my lord, friends were, my lord, in the said, my lord, quarrel. My lord. And petitioner is, my lord, a student of SS first year, my lord. And his examination is, my lord, scheduled to be held from, my lord, 5th of March, my lord. Today I have filed an affidavit, my lord, additional affidavit, my lord. In the affidavit, my lord, page 26, my lord, I have annexed the, my lord, examination schedule, my lord. And in the petition page 10, my lord, it's my lord, admission, my lord, admission receipt, my lord. And as on date, my lord, 43 days in custody. My lord.
Yes, case diary received, my lord. In some of the cases, your lordship, yes, your lordship was pleased to grant interim protection, and thereafter those matters were fixed on 26 to 26. Considering that regarding their ensuing, my lord, examination, that was from restarts from yesterday, 11. But this is the, my lord, document he has annexed, that is regarding his SS first year, regarding SS first year examination. And regarding the my lord, incident, although the FIR, my lord, that incident occurred on 31/12/2025. And my lord, here the FIR is lost by one Benita Hazarika. Unfortunately, my lord, while these accused persons, all these, my lord, neighboring people actually went there to, my lord, there is a fight between all these persons, my lord, while they went there to actually save one, my lord, Obhigyan Rajkumaar. And there and in that, my lord, while fight was going on, my lord, and suddenly someone, my lord, struck him with a, my lord, button, then, my lord, on his head, and thereafter, my lord, he succumbed to the injuries, my lord, in the hospital later on, my lord. My lord, before that is the FIR lost by, my lord, Benita Hazard. But one other, my lord, one GD entry I have found in the, my lord, case diary, that was lost by Omiron Raskwa, where from actually the incident starts. I would like to, my lord, read that FIR first. Your lordship can come to know about the incident, my lord. That was ultimately, my lord, tagged along with the as supplementary FIR along with the present FIR, my lord. বিনীত নিবেদন এই যে যোৱা ইংৰাজী 30/12/2025 তাৰিখে নিশা প্ৰায় 10:45 বজাত পদকীয়া আছিকুৰ ৰিজৱানে প্ৰথমে ফোনযোগে কোনো কাৰণ নোহোৱাকৈ দাবী ধমকি দি প্ৰাণে মৰাৰ ভাবুকি দিয়ে। তাৰ ঠিক অলপ সময়ৰ পিছতে উক্ত পদকীয়াই লগত কেইবাজনকো লৈ আমাৰ ঘৰত অনাধিকাৰ প্ৰৱেশ কৰি হাতত মটৰচাইকেল, স্কুটিৰ চাবি, বাটাম, ৰড আদিয়ে দলবদ্ধভাৱে মাৰপিট কৰে আৰু হুলস্থুলীয়া পৰিৱেশৰ সৃষ্টি হয়। চিঞৰ বাখৰ শুনি ওচৰ চুবুৰীয়া ওলাই আহি কাজিয়া এৰুৱাই দিবলৈ যাওঁতে ওচৰ চুবুৰীয়া কেইবাজনকো আক্ৰমণ কৰে আৰু ওচৰতে থকা আমাৰ নিচা দুৰ্গা প্ৰসাদ জয়ছোৱাল, হি ইজ দ্য এডভকেট, জয়ছোৱালকো কাজিয়া এৰুৱাবলৈ আহোঁতে পদকীয়াজনে দলবদ্ধভাৱে প্ৰাণে মৰা চেষ্টা কৰি চকুৱে মুখে গুৰুতৰভাৱে জখম কৰে। ইয়াৰ উপৰি ওচৰ চুবুৰীয়া মৃন্ময় হাজৰিকা was my lord ultimately my lord মৃন্ময় হাজৰিকাকো পদকীয়াজনে মাৰি গুৰুতৰভাৱে জখম কৰে। তেওঁক এই নিশাই যোৰহাটত চিকিৎসাধীন অৱস্থাত মৃত্যু হয়। মোৰ দাদা অনুভৱ ৰাজখোৱা ওৰফে ধুনধুনক হাতত মাৰি গুৰুতৰভাৱে জখম কৰে। ওচৰ চুবুৰীয়াৰ মানুহ ক্ৰমে যেতিয়া গোট খাবলৈ ধৰে, সুযোগ বুজি আক্ৰমণকাৰী পদকীয়া দলটো পলাই যায়। যাবৰ সময়ত পদকীয়াগণে আমাক প্ৰাণে মৰাৰ ভাবুকি দি কয় যে আজি তহঁতি বাচি গলি যদিও এইকেইদিনৰ ভিতৰত তহঁতক মাৰি খতম কৰি দিম। So this is the ZD entry that was lost by the my lord one informant Omiron Raskwa. This my lord actually initially that from that FIR it reflected one Asikur Rizwan, actually in somewhere it is Asikur Rahman, my lord. He initially made a phone call to that my lord Raskwa, and thereafter my lord he my lord threatened that him that yes I am coming, you wait there. Thereafter all these accused persons in a group my lord 20 to 25 students my lord, actually one by from the FIR it reflects that on that night my lord one birthday party was going on in the residence of one of the accused person Ankur Jyoti Sharma. Thereafter my lord, after getting phone call in that my lord birthday party, they all together my lord in bike, scooty my lord, they came to the residence of this Anubhav Raskwa my lord. Thereafter my lord called him and my lord created a situation there, and thereafter by way of all these my lord weapons they carried with them, by my lord even key of those my lord scooters, scooty, and along with them my lord batam also there my lord, that is also mentioned my lord regarding the weapon which they have carried along with them. Thereafter brutally attacked those my lord the Anupam Raskwa and his brother my lord. And thereafter all these neighbors my lord went there actually to save my lord the victim Anupam. And thereafter during that my lord scuffle, all these accused persons brutally attacked my lord Minmoy Hazarika, and ultimately Minmoy Hazarika succumbed to the injuries and other accused persons were injured my lord. And here my lord statement of the my lord all the eyewitnesses is available in the case diary. My lord initial the name of one my lord regarding that incident, the fight between the accused persons my lord initially starts from a phone call initially, and during investigation my lord I would like to my lord point out one note my lord. Victim Onuron Raskwa my lord came to the police station and handed over one pen drive containing a video recording of the phone call of the accused person in connection with the case. After examining the video recording of the phone call, it is noted that 3 or 4 boys were threatening the victim using foul language. After further examining, it was found that the contact number from which the phone call was made was of accused person Mriganko Paul. The victim Onuron Raskwa stated that the voices which threatened him over that phone call were Asik, Rian, and Mriganko. So, my lord, all these accused persons, my lord, initially, my lord, make phone call to Onuron through my lord the phone number of one Mriganko Paul. Thereafter, all these accused persons, after threatening my lord, that is not a my lord, that was a voice call, my lord, that is voice recording. Video recording was also there, my lord, and from that video recording, 3 accused persons, Asik, my lord, Onuron Raskwa, all those accused persons were identified. And thereafter, my lord, during investigation, some police has also, my lord, seized some of the vehicles therefrom, and from the recorded the statement of the witnesses, and from the statement of witnesses, the name of the present petitioner also, my lord, comes to light. He was also along with other accused persons where my lord actively participated at that point of time while all these accused persons assaulted the victimized person. And PM report is also received, my lord. PM report.
We can do one thing. The other matters is fixed on 26.
26.
They are all interim.
Yes.
So, because there may not be, should not be any, the order should be in any time. So that's why I thought that this matter, because it has to be finally disposed of because DD has already been here. So let this matter be also listed on 26.
126.
That will be better.
Yes.
Truly. What are the other numbers? Can you
my lord.
For three, petitioner number
Three.
three.
That plea is applicable to that petitioner lordship. And regarding other 1, 2, and 4, they were arrested on 7/1/2026. That is before lodging of the present FIR, my lord.
No, your present petitioner was shown arrested on 19/1.
In this case, 19/1.
And in earlier case,
Earlier case, the petition number 3 is arrested on 13/1/2026. So I've taken that plea earlier occasion, my lord, that this earlier case was not mentioned in the following report. That is there. But other lordship petition number 1, 2, and 4, they were arrested on 7/1/2026.
FIR was of this.
FIR was lost thereafter, my lord.
No.
This present FIR.
Present
FIR was
lost on
after earlier arrest, my lord.
8/1/2020.
8/1.
Lordship. That means at the time of lodging the FIR, we were inside the jail, my lord.
No, these are all for petitioner number 3.
The earlier first.
No, I'm not on that. I'm saying that petitioner number 3 got arrested in this connection as a shown arrest on 19/1/2020.
Not shown arrested on 19/1/2026. But lordship, earlier case, petition number 3 was arrested on 13/1/2026 after lodging of this.
FIR was lodged on 8/1.
8/1. And
the others?
Others were arrested in earlier case on 7/1/2026.
Prior to lodging of the FIR.
Instant FIR, lordship. So, my lord, I have raised that question that in the forwarding of the petition number 3, the earlier this case was not mentioned. So, in this case, for others, my submission is that, my lord, while we were inside the jail, this FIR was lost. And lordship, there is no specific allegation against the accused persons that they are not named or they are involved or the informant has seen that these persons lifted the cow, lordship. Lordship will find the FIR at page number 2.
Whatever, yeah, the question is that petition number 1, 2, and 4 were in jail.
All are in jail, man.
No, he was not on jail.
4.
3 was not on jail.
All are in jail.
No. 3 was arrested in earlier case only on 13/1.
No, 3 was in 13/1/2026. Then shown arrested in this case, all are in 19/1/20. I'm clearing the distinction. This is some.
No, I'm not. I can understand. All are arrested, shown arrested on 19/1/2026.
Yes.
Particularly the petitioner number 3 was earlier arrested on
13/1.
That is after filing of the this present
Yes.
FIR.
Lordship.
And your plea is that without mentioning that the
This case.
present pendency of this case, the forwarding report was there. But in other petitioners, they got arrested on 7/1. At that point of time, the
present FIR was
present
not.
FIR was not lost. And you all were in jail.
All were in jail.
At the time of lodging the FIR.
No, all are not jail. Only 1,
2, and 4 were in jail.
Yes.
Yes, that's what I'm.
Yes, lordship is correct. So, my lord, in this case, in the present forwarding report, what I found in the shown arrest application, lordship FIR will find at lordship page number 12. Lordship.
Yes.
May I read, lordship? Most respectfully, lordship, most respectfully, I beg to state that on 26/12/2025 at around 3:30 a.m., some unknown thieves cut the door of my cow shed and stole my 2 cows as mentioned below, taking them away in a white VIP car. It is stated that although I woke up from the sleep upon hearing the sound of the car and followed the car sped away towards Kamarkusi. Thereafter, case was lost on 8/1/2026. Thereafter, lordship shown arrest or prayer is at page number 16. In page number 16, in the second paragraph, the investigating officer has mentioned that during investigation, it is learned that the following accused persons who have been arrested in connection with Naxala case number so and so and so are suspected to be involve accused persons of above referred case, and they are required for custodial interrogation. They were suspected, but my lord, they were inside the jail when the cows were lifted, my lord. So only merely on suspicion they have been implicated in this case, my lord. This is
They
the
were
case,
in police custody also, no?
my lord. They have
Yes,
taken the police
police
custody.
custody.
2 days police custody were there, lordship.
2 days.
2 days. Then thereafter, my lord, in the main case, all the accused person got bail, my lord. Dishonorable court granted bail to the accused persons, my lord. So, my lord, we are the local person, my lord. These are the lacunas of the case. In this case, my lord, regarding 13, I have taken the plea that this was not mentioned at the time of arrest, my lord. That is the lordship is aware, and I would like to place this one, these two judgment, my lord. I would have put. I would have done. Objective. So, my lord, we will cooperate with the investigating authority, my lord, with any stringent condition, my lord. In the main case, perceived dishonorable court granted bail, my lord.
Yes, Mr.
My lord, here I have received the case diary, my lord. From the case diary, it reveals that, my lord, they all of them involved, my lord. They are the organized, my lord. They are the all of them, my lord. There are 3 vehicles they have used, my lord. All of them luxurious vehicle, my lord. Sometimes it is Creta, sometimes it's Brezza and Scorpio, my lord. And on that day also they have taken one, my lord, luxurious vehicle, white color, my lord. And they have taken 2 cows from the house of the complainant, my lord. All of them are 10 months pregnant, my lord. That was they have taken, although the owner of the complaint, my lord, woke up, but try to find out, my lord, but they have left with the vehicle, my lord. And their present petitioners are also involved in the other cases also, my lord. That is Patsala PS, my lord, the original case, my lord. They have arrested, my lord. Same case, my lord. Here, that's why 3174 edit, my lord. 317 subsequent for edit, my lord. Receiving stolen property. That section also added, my lord. And regarding the, my lord, other allegations, my lord, lordship may kindly place only one statement of that. Also, the 2 cows in the, my lord, defined person, and they have divided the amount, my lord, among them, my lord. These statements are also there.
Witness नाही ऐकत. माहिती कोण आहे? विटनेस नाही ऐकत त्याच्यावर आवडत. हे तिकडे दाखव ना. तिकडे ते स्टेटमेंट लिहिते.
No, we have which or what? So it's a case that the incident took place, in fact, on 25 in the night, 25/12/2019, that is day 26 almost. So at that day incident, I thought that it was taken place on 8th of this month.
Right.
But at that time, they were not in the inside the jail.
Mine,
They were outside.
outside mine, outside. They're outside mine,
They all are outside.
outside mine. Incident was 26th.
Yes.
But my lord, there is delay in lodging affair.
That is the
There is delay in lodging affair. If any cow stolen from my house, that it was the duty of the informant to lodge the affair instantly, my lord.
That is not there.
After our arrest, this was a concocted affair lodged, my lord. But right now, my lord, as in the main case, lordship, already they got the bail, my lord. So, my lord, they are local person with any stringent condition may be released, lordship. And regarding the PW 13, we have taken that 3, lordship. Sorry, 3. Petition number 3.
Obviously, they are in custody for some days. That
And
was
only
the only
23
consideration.
days.
Otherwise,
Here is only 23 days, madam. Here, 417 is 90 days of whatever edit manner. And from the player of the IO manner, it has edit manner. 417 subsection 4, as they are also involved in
it has
another
already
case,
been added.
another,
Interesting.
and materials are also there.
Very-
Against them. And objection is bail objection from the IO here is that manner. Others are yet to be arrested manner who are involved from to whom it was sold, purchasers, etc. They are yet to be.
It is. Oh, it is. My lord, I would like to show one more thing, one line, my lord. Kindly see page number 70.
Yes, number 7.
17.
Yes.
In this is the forwarding report when they were forwarded to the CGM, my lord. It is in the third line, it is mentioned, no need to more interrogation. Because during investigation, he was thoroughly interrogated, and during custodial period, food and other, that is decay, so that has been mentioned for all, my lord. No need to more interrogation. If not needed, my lord, in that case, any stringent condition, my lord. If they are again involved in this case, then this will be the precedent, my lord. But in earlier case, they all are arrested in one is 5, and then other 3 are arrested on 7/1, and one is on 13. More than 1 month, my lord.
And vehicle also seized from the Gorsuk Malat private parking Malat. And one
Oh,
visa is
got bail, Mohit.
visa Malat. Here is the Malat without number plate. One Creta was one Scorpio. That's are used for still in the
Luxurious car.
luxurious car.
My owner got anticipatory bail, my lord. We have the order copies, my lord.
What is the different?
Owner involved in this, if they are not involved, that is why lordship, the vehicle also not involved, that is why my lord, owner got the interim bail. In AB 180, my lord, we have the copies, my lord, we can supply that.
But the present petitioner's involvement is.
So they are not the owner of the vehicle, my lord. AB.
No, they are not the owner, they are involved.
Fine.
My lord, only on the ground that lordship humble prayer before this honorable court, my lord, they are inside the jail for from the main case, my lord, more than 1 month, my lord. So lordship, as in the main case, they got the bail, my lord. Here I have shown that the no need for interrogation if they are not needed for interrogation, my lord. In that case, any stringent condition, my lord. As the first case, they got bail, my lord.
This is not the main
Well,
case, Malad, subsequent case, Malad. It is
that
the
is why-
case, Malad.
That is why
Another
if
case,
they,
here is
if
another case,
they
Malad.
will again involve these are the case, then they can reflect in the forwarding my lord. They are involved in this case. That is why they should not be got bail, my lord.
They are the habitual offender.
That is, they may say anything, my lord. Habitual offender or something after arrest, police after arrest, my lord. If it is, my lord, I should not make some other submission. From the first very day, I have stated that if they are habitual offender and lots of cases are pending against them, it should be mentioned in the forwarding report. As this is the law, my lord. And that is not in regards to petition number 3. And for others, my lord, in the main case, they got bail, my lord. So that is why, my lord, if any stringent condition, local person, my lord.
Things scanners and it comes vision. We learn it vision every then application. Submitted notice that the petitioners as the of the said incident at the time of lodging the FIR of 8, they all are in police custody in connection with another case in connection with the petition number 1 1 3 1 2 4
1 2 and 4
were in custody since 7/1/2026 in connection with the said Patsala case number
3 of the 26 same number, only PS
case number 3 of the 26 when the FIR was lost, and in the same time the petition number 3 was also arrested in connection with said Patsala case number on 13/1/26. She further submitted at the time of filing at the time of submission of the forwarding report on 13 no, on 9 at the time of shown arrest. No, sorry. At the time of forwarding of forwarding of the PW petition number 3 in the in the said Patsala case number PS case, there was no mention about case of the present case, though the FIR was lodged on 8/1/2026. Thus, the investigating authority did not inform the court as well as the petitioner about the pendency of the other FIR against present petitioner. Further, she submitted that all the accused petitioners are behind the bar. All the accused petitioners number 1 and 4 are behind the bar in connection with the present case. No, in connection with this case, from last 23 days, and they all were shown arrested on 19/1/6. Thus, the IO got sufficient opportunity to interrogate them, keeping them in custody. In the same time, custody. Further, she submitted that the FIR of the present case is also lost with a delay of 12 days, 12 days delay, and the FIR was lost on 8/1/2026. So, as per the statement made in the FIR, the incident took place on 26/12/2025. 26/12/2025. That apart, as per the statement of the FIR, the informant also saw the car while taking away the cows from cow shed. All the petitioners got bail in connection with the earlier case, that is the Pachala case number 3 of the 26. And 26, and all the petitioners will abide by all terms and conditions if they are granted with the privilege. Is women objection and submitted that it's not the case to extend the privilege of bail to the present petitions. And from the statement available in his diary, it is seen that they are the habitual offender and they have committed both the incident of they have committed the which they have already admitted at the time of correcting their statement. More so, considering the nature of considering their conduct of the accused petition, who are the habitual offender, the IO also made a prayer for addition of 317.4 BNS in the present case, where the statutory period is of 490 days. Mr. Sharma further submitted that they used to steal those cows in a very luxurious car, and after stealing those cows, they used to also sold the cows to the other persons. Mr. Sharma accordingly submitted that this is not the case. Extend privilege of bail the petitions. The sufficient and case record, and seen that there are sufficient progress in the investigation, and at the same time it is also seen that after their shown arrest, all the accused petitioners were also in police custody for 2 days, and after completion of the 2 days, they were also forwarded for the judicial custody as further custodial interrogation was not required as per the Act. Considering this service the length of detention already undergone by the accused petitioners, I find that custodial interrogation may not be necessary in the present case. The petitioners are hereby failed. This deputy. What should be the policy? Okay, we are done.
Deeply obliged. To the satisfaction of Cesium Bozale. Cesium Bozale. Well, I have placed the anticipatory bail original order copy. Can I take back that? Look? Obliged.
Similar case, my lord. I was arrested on 5/1/2026, my lord, before lodging FIR, my lord.
Same case?
Yes, my lord.
Same case, same. One paramount here, I have taken statement, his statement. Lal.
M. Lal Mia, na?
Lal Mia.
Lal.
Oh, that is the statement.
Right.
So your only profession is to this is the only profession. Yes. Oh,
Nowadays,
Good.
in earlier days, my lord, cow theft is very,
Where they sold the cows now, then it is transported to Bangladesh or
Well, it is. And some butchers also there, just having
pardon?
beef. Surely there's a beef also.
Uh-huh.
That is also there.
But openly it is not
Well,
market is there.
not openly, but it's in different places it is also
in
happening.
earlier, my lord, cow theft is a social stigma. There is, if there is a cow theft, my lord.
Huh.
Now, my lord, that is, my lord,
Profession. There is a profession. Luxurious cars are also used.
Huh.
When they're and found some cows are taken in the vehicles. It is going on.
How they put the cows in such a luxurious car in such a
Dicky also in the seat under seat.
in the second back seat, I think.
I think back seat, my lord, and
It is open the back seat.
Open
And
back seat.
cows are also lucky that they can travel in their
In
luxurious
luxurious cart.
SM. Okay. Mark to one statement of this Lalmia, and what about the other co-accused persons?
That is there. All of
Statement is also there.
all of them.
All, na?
Others of the next bit.
One co-accused is also
My
there.
Blush.
Please, Lord.
Yes.
3 years bail application. Case diary was called for.
Did you receive my?
Petitioner, as per instruction, Lordship, he has appeared before the investigating officer.
He already appeared.
Appeared. Lordship, as per FIR allegation is upon one Mriganko Kolita. The only reason the petitioner was apprehending arrest because this person stayed in the area in the complex of the present petitioner, and he has some he deals with the main accused deals with some car business, second-hand car business. So he used to park the vehicles in the present petitioner's house. So the police were visiting the present petitioner also. Lordship, after the interim protection was granted, I have appeared duly.
So he stays in your house as a in a rented premises or
Yes,
what?
yes, granted.
My lord, case diary received, my lord. He appeared statement, but there are materials, the vehicle not yet recovered, my lord. The present petitioner one, although FIR in the allegation against only one, my lord, Meganko Kolita, but during investigation, the present accused person along with one Meganko Kolita and Hemant Soikiamal sold the vehicle to someone of Nagaland, namely, my lord, one Tonu. And thereafter, entire sale amount actually, my lord, credited in a joint account, which that joint account was run by the present petitioner along with one, my lord, Ankur Bora. And during investigation, the police has found no, my lord, materials against Ankur Bora. Ankur Bora was not yet arrested. Actually, he is running the present petitioner is running that account. And thereafter, that entire sale amount was distributed to Meganko Kolita and Hemant Soikia and, my lord, the present petitioner. So there are materials, my vehicle not yet recovered. In fact, he along with the other accused persons, Meganko Kolita and, my lord, that Hemant Soikia sold the vehicle to someone at Nagaland.
Apart from that, Lordship, in the FIR only Miganko Kolita's name is there.
CDR analysis, there is close contact between the present petitioner and the main, the FIR named accused Miganko Kolita. And in fact, in his statement also, my lord, he in fact admitted, my lord, stated that he along with Hemen Shaikia and
In Nagaland, it has sold.
yes, yes. Someone to know, but now my lord, only they knows who is the no. Police till now, my lord, they fail to identify who is. Police is trying to find out the vehicle, my lord, till now not vehicle. তো গাড়ীখন 3 লাখ টকাত বিক্ৰী কৰি টকা আমাৰ মাজত ভাগ বতৰাই লওঁ। And against Miganko Kolita, there are other, he is a habitual offender. There are other cases also pending against him. But the present petitioner, in the present particular case, he is also involved. He alone, actually, he insisted, to sold the vehicle, and thereafter all these three accused persons sold the vehicle to someone at Nagaland. Regarding that, vehicle now investigation is going. And who is that? Tanu, regarding that aspect also investigation is going. Vehicle market.
As per my instruction, Lordship, the petitioner and they do have a close contact, Lordship. Present petitioner and the person who is named in the FIR, Miganko Kolita. As per my instruction, they stays in the same premise. And the FIR name accused is the tenant of the present petitioner. And that is there, but already my statement has been recorded, Lordship. When considering the offense.
Think that this custodial interrogation will be required.
Vehicle not yet recovered, although after obtaining interim he appeared, but my lord,
I have been cooperating, and since then the investigating
for recovery of the vehicle, because to whom they have sold the vehicle, without custodial interrogation, ultimately
Lordship, IO has, after taking my statement, IO has not once has called me in the police station for any kind of interrogation.
Is there any note of the IO also?
Yes, my lord.
No, regarding his custodial interrogation is required.
Yes, ma'am. Detail, your lordship may kindly tell.
Before custodial interrogation, IO could have called the present petitioner, because already the conditions are there that he has to cooperate. But after recording my statement, not a once
his statement and other
the petitioner was called for.
Otherwise, my lord, without custodial and no purpose it is served, because my lord, once he appeared, my lord, he has not disclosed, only stated that he has sold the vehicle to one, but he failed to identify who is the person to know. So otherwise, in this type of offences, without custodial interrogation, it is difficult for the police to find out. That statement also is also there.
Regarding bank statement, there might be transaction, but whether that transaction is pertaining to the LS vehicle or not, and stringent condition may be imposed so that I will keep on appearing whenever the IO asks. because until now he has not asked for my appearance. I have appeared as per the Lordship's direction, Lord. And after that, the IO has not seek for any appearance, Lord. And I am the local person, Lord, within the reach of the investigating officer, and he can call me anytime if there is any such.
Now that is one point. Why they are not calling him again? Because recovery is not there, so his cooperation may be required. That is not free.
Because-
But he is not been called by the police till date.
Otherwise, that is his submission, but my lord, here from the not after obtaining interim order, he appeared before the my lord IO. So right now, regarding after that, my lord, regarding from the bail objection, my lord, it reflects that although he appeared, his statement, he in fact admitted, my lord. His statement is also ahead.
Yes, that is there.
Now after that, my lord, was mean only has to, my lord, recover the vehicle. Again, if my lord police call him, because after his admission, my lord, no purpose would be served, my lord.
No purpose of question is there. Suppose if his custodial interrogation is required, police duty is that once recorded is not.
Regarding that aspect, my lord,
may not be sufficient.
yes.
Call again. He should be called again in the police station so
Well,
that
regarding
further
that,
inquiry,
regarding
so the
that,
recovery and all.
yes.
And that IO can
Regarding
put it
that, I
in
will have to get instruction, my lord, whether my lord IO has again called him before to appear before the IO. After initially, my lord, after his appearance, my lord, whether he was again interrogated or not, my lord, all those things.
If that was so, Lordship, IO could have put it in the objection of that.
There is
Although
no such note in the objection
that,
that in spite of his direction, he is not appearing or cooperating. That is not there in the objection. Otherwise, there are materials. I do admit there are materials. Some materials are against him also. But surprisingly, if there is this thing, it is not also there that regarding his cooperation also, it's not there that he is not
Otherwise,
cooperating or not
against
disclosing.
Migango Kolita, my lord, he is habitual. There are other cases that is there. That is the case numbers also mentioned. Only regarding that vehicle not yet. Otherwise, if he cooperates, then I would like to leave it to your lordship, considering that.
Because even after he cooperating, suppose there is no statement in the objection filed by the that he is not cooperating or willfully. I mean, these things are not there. Like he is not fully cooperating or he is not disclosing some facts. These are not there.
He appeared, but my lord, main difficulty is that vehicle not yet recovered.
Not yet.
that at any time, if investigating officer seeks the petitioner's presence,
Mr. D. may take it. We bought. It is submitted by Mr. D. He is innocent. He is no way connected. The only reason behind his the anticipatory bail is that this is searching for him as the main accused Mriganka Purita was residing in his premises, in his rented premises, and he also dealt with the business of some second-hand. After obtaining the order of interim pre-arrest bail, he appeared before the IO and cooperated in the investigation, and his statement is also accordingly recorded. Everybody is still ready and willing to extend his cooperation in the further investigation of the case if it is granted bail to the arrest. Next, Mr. Portfolio PP submitted in Mystica that the present accused petitioner is very much involved in the arrest of rather the present accused petitioner along with one MN and the main accused Mekang had sold the vehicle to one person from Nagaland, but till then the vehicle could not be recovered by police. Further, he submitted that from the statement made by the present petitioner as well as from the matters in the case diary, it is seen that after selling the vehicle, the entire amount was transacted in the account of the present petitioner along with one along with one person, along with another, and presently he is also running. Mr. Court recording the days of petition and submitted that may not be the case to extend privilege of free respect to the petition. Next, Ms. Mr. Mary Delanet, counsel for the petitioner, submitted in this that after recording the statement by the investigating authority, he was never asked to appear further in the police station, and he had not received any notice to that effect, though he was ready and willing to extend his cooperation. At the same time, he further submitted that there may be an account but cannot be considered. The account was that his sale amount was credited in the sale. Said that he is ready to appear before the eye as and when his presence is required, and will also fully cooperate in the further investigation. During the submission made by non-consequences and on perusal of the case diary, seen that there are some materials against the present accused petitioner also, who is also seems to be involved in the alleged offense. However, it is the fact that after his appearance, after recording his statement by the eye, he was not asked to appear before the eye of pardon, and in the same time from the bail objection also it is seen that there is no statement made by the eye that he is not fully cooperating in the investigation of this case. Nor there is any statement that he did not appear before the police station even after receiving notice of the station. Only considering this aspect of the case, the bail granted to the present petitioner dated so and so is hereby made absolute with a direction to the present petitioner to appear before the IO every fortnightly. Every fortnightly if it is required by the IO for the purpose of investigation. The IO is also further directed to issue notice to that regard if his further interrogation is required in the investigation. With that observation,
Deeply obliged.
आपने का notice दीजिएगा और उत्तर आप दीजिएगा. Next. Yes.
May I please your lordship? Item number 32, criminal appeal 233 object 24. Your lordship, my senior is out of station. Kindly give us next date.
32. You're for the appellant or the appellant? Who is your senior?
MM Rahman.
MM. Your MS? Your good name?
Hasina Khan.
MS Hasina Khan. Each learning from the appearing on behalf of Mr. MM. The body and case counsel for the appellant that is supposed in confidence is not. Cannot fix it. We cannot fix the data after 2 weeks. It will come. Yes. We could get. No. Otherwise, you were on interim.
Yes, Lord.
James.
Yeah.
আপোনাৰ 18th.
You are Mr.
I am in Lord.
Mr. Delaney petition. It is submitted by Mr. Sharma that the report is received from which station it is? Botadraba.
Botadraba Police Station.
Botadraba Police Station, Nagaon. And it is reported by the officer in charge that the said police station that there is no case pending of the register against the present petitioner in the Botadraba Police Station till date. In view of the above observation, the present petition stands to vote. The interim granted earlier dated 18/12/2022 is hereby also granted. With the above observation, the case stands.
But here, item 20 charge sheet submitted by
Are you on interim there?
interim.
Interim was there. You are Mr.
SK Sarfraz Karim.
S.K. Sarfraz.
Karim.
S.K. Sarfraz Karim, the learned counsel, the petitioner, but we shall be appearing state. Yes.
I charge sheet number 1/26.
1/26.
Dated 31/1.
31.
26.
So we are extending your interim up to 15 days. Within 15 days, you appear before the learned trial court below with a regular bail application that may be considered.
Yeah, please, Your Lordship. Case diary was called for. Page 18 is the agenda.
Civic is dead.
Page
Page
18, ma'am. 60 lakhs of fake currency was recovered from a vehicle. There is the allegation. And there are two named accused, one Rashidul Islam, one Bikash Gogoi.
One Rafiqul Islam
And one Bikash Gogoi, their named are there. We have no connection with that accused persons, named accused, but some indirect contact was there. In the sense, my lord, I borrowed some money from one Ismail. And when I wanted to repayment, then he gave a number of Rashidul Islam. And I made repayment.
You earlier borrowed money from whom?
One Ismail.
Ismail.
And he gave a contact number that is the Rashidul Islam. I repaid some money through UPI to the Rashidul Islam. This much of contact, this much of my lord connection I have. I don't know actually physically Rashidul Islam. And we had an agreement also with the Ismail that I have annex also and money receipt also. Nothing was recovered from me.
So then why you were apprehending arrest?
My lord, the one order also has been, one warrant has been issued against me also. That is base 25.
25.
Right. I was not aware about that.
No, it is a charge sheeted case.
No.
No charge sheet. Acha, so prayer was made. Okay.
Prayer was made by the IO.
Yes.
Whose, my lord, named accused, they are also suspected. It is reflects in the area. I'm not on that because named accused also, they are also suspected. Is written.
No, but 60 lakhs recovery was from whom?
Them.
From Rashidul.
From
Rashidul.
Rashidul and Vikas Gogoi Lord.
Yes.
There are Lordship 161 statement Lordship. In there, they have not named the present. But in one of those 161 statement Lordship, Rashidul Islam have named that he was in connection and he gave the money to do this fake currency business. Lordship. But Lordship, in three other state 161 Lordship, they have named one Masood Rahman Lordship. That the amount that 60 lakhs was recovered Lordship, it was given to Masood Bhai. It is in here Lordship, Peruz Lordship, and he was connected because Lordship, as learned friend have told Lordship, due to some bank transaction. Otherwise, in the forwarding Lordship, the accused person have not named, co-accused have not named them, only in 160 only. And the other Lordship may Perus Lordship. Two are in English Lordship. I can read. The above name, this is the Bikas Gogoi Lordship, 161. The above name and so my Islam, Rasidul Islam, true. Rasidul Islam is my friend. He is already behind the bar. He told me that a party of Dimapur is coming to Manja to collect fake currency note of the rupees 60 lakhs on exchange of rupees 35 lakhs, and I would receive an amount of 10 lakhs for it. The amount of fake currency was delivered by one Marom of Gwalpara. This name is little bit Marom or Masum is there. Currency was delivered by Marom of Gwalpara, Lalmati, Gauhati, and Residual brought it to my home, and we hired two vehicles and came here. Marom is also known to me, and I have his number in my mobile phone. I know that Marom used to deliver fake currency in exchange of original. This is the 161 of Bikas Gogoi, then other lordship of Rasidul lordship. The above name and so, I have collected an amount of 60 lakh from Marom Bhai or Masum Bhai of Gwalpara, and on payment of 2.20 thousand at Lalmati. And I came to Vikas Gogoi's house and planned to deliver at Manja, Karbi Anglong to a party of Manipur. We hired two vehicles and came to Manja, the Manipuri party, so and so lordship. But lordship in one lordship may parasite. That in that regard, he have named this present petition. That is lordship in Assamese lordship.
It is whose statement?
It is a statement of Rasidul.
Rasidul, just now you have read.
There are 45161 during the course of investigation.
Several times.
Several times. 16, but he have altogether named some other person. Only in one similar person is Masum. All the statement, but in one statement he have named him.
Your name is?
My name is
Lulu.
nickname is Lulu.
Mohidul Islam.
Mohidul Islam.
His statement, oh,
No,
this is
430.
AB.
What? I will cooperate, my lord. I will.
All the, uh, in- yeah, all the- all the syllabus.
Yes, it is admitted.
For which protect the barcode.
But what quantity of the bank amount of the money they have transacted?
I borrowed 6,50,000 from Ismail.
Hmm.
Then I transacted 20 or 30,000 by UPI in phone of the one of the accused Rashid.
Hmm.
That is I had. And is the statement of the accused possibly? Supreme Court said a statement of the accused may not be considered for consideration of bail. Witnesses' statement may be.
At this stage, these are only the seizure witnesses. For other witnesses, how can you get now? There's only the seizure. Any other note from the IO? No. Mr. Kedarnath Council. But Ms. A. Begum Kedarnath. He is himself very involved in alleged offense. The fact that he knew one Ismail from whom he borrowed about 7,000 as a loan. When he tried to repay the same, said that Ismail asked him to make the repayment in the account of one Rashidu. Accordingly, he paid fees in the bank account of co-accused Rashid. The record is no picnic. No recovery was also made of the original petition. Nor he knew the Rashidul and Vikas Gogoi, the co-accused persons, personally. Is treated and within his cooperation. If the the it's we use the amount was the decided that they were supposed to deliver the they are supposed to get the currency from one muscle tails 2 days of money. She further submitted the exception in one statement that it used. There are no other bedrooms in the case diary. Case diary against some bank institutions have already been collected during investigations. Statement made by the court which as well as witnesses and other aspects of the case that custodial interrogation represent petition may not be necessary. However, his presence may be required in a police station for further investigation of this case. Hence, the petitioner is here for investigation if it is different, if it is required for the purpose of this. Apart from your the other directions, you are also appear
Before the,
will appear fortnightly before the
eye.
concert. Yeah.
Of that.
Lordship, my objection is
Yes, I have record.
May I please, Lordship?
Yes.
For
City not received.
Lordship, kindly have a look, page 9, Lordship. FIR,
No,
Lordship.
no, what to do? You are not on interim.
Not in.
No.
You are not also in interim. So at this stage, we cannot consider anything. And this is the what date? This 2-3 days gone or what? This is
No,
second day.
Second day.
Okay, let's see
My lord.
from where it has to come.
Sirang, my lord.
Shirang.
Sirang, my lord.
Then when it
Today is
can be
12,
fixed
my
because
lord.
there is no interim. Okay.
25th, my lord.
Lordship, the short date.
It may not come also.
My lord.
Better to take on 25th only.
Lordship, all the accused already released on bail.
Huh?
Some of one 9 to 2025 peace court also released.
That is the perhaps regular bill. It has
Regular
an
bill, I think.
anticipated bill.
No,
Regular bill.
just regular bail, but without city.
Regular bill.
Regular bill.
Length of detention perhaps.
Now see, for that thing on the first day of your filing, you would have pressed for the interim. You did not press, and most probably considering the
Material.
case material, whatever in the FIR, that was not considered. So at this stage, it's not proper to consider anyway. We'll give strict direction to the IO for providing us the issue reminder with a direction to the IO to furnish the case diary on or before the next day of testing. When it can
25th.
25th. Let's see if it doesn't come, then you
My lord, my lord.
Obliged.
25.
May I please, your
yes.
a report call for
Report
is called for.
Yes, we have received the report.
My lord, receipt.
Till now, your no FIR has been registered against you. In your this which PS this one? AW?
All women.
Yes.
Huh?
All women.
All women.
All women.
Oh, all women. Acha, acha. All women police station, that means Panbajar. You are Mr. Chaudhary?
RL Sutia.
Oh, sorry, RL Chutia. Heard Mr. RL Chutia, the learned counsel for the petitioner, and also heard Mr. B. Sharma, the learned additional PP. Report received from all women police station, Gauhati, wherein it is reported that till date there is no case has been registered against the present petitioner, nor any complaint received by the council. In view of this, the present AB stands disposed of, and the disposed of, and the interim granted to the petitioner dated 5/2025 is hereby vacated. However, the petitioner will be at liberty to approach this court in the event of registering any case against him.
Well, a report may be kept as a part of the record.
Sorry,
in the
report be-
earlier case also, ma'am.
Okay, report be kept as a part.
In item number 19 also.
In item number 19.
19 also we have.
Pune Lucille dictation. দেখে দেব। 19 to kept part of the record.
19.
Yes, we'll
May I please your lordship? Actually, it was fixed for LCR. Whether service complete or not.
service is completed.
Yes.
Completed.
Yes, your lordship.
How many respondents are? State is one and another?
State of Assam. There is only one.
That is
State
the
of Assam.
state. So I've received the case record, na?
Right.
It is you are against the judgment of us by the learned section of Sipsagar on 7/12/2023.
Yes, your lordship.
You are MS?
Miss Enkasha. May-
MS and question. Addition was
Your lordship, it is requested to fix as hearing.
MS and question. Did not This PCR has already been received and is already admitted. The matter be accordingly listed in final hearing. Yes, what you are submitting?
Sorry, your lordship.
No, what you are submitting?
It may be fixed as a hearing.
Yes, yes.
Fixed for hearing.
You want any fixed date here? Now
Yes,
see,
your
if the
lordship.
fixed date will be, then it will be it will go in the month of March. Otherwise, we may list it after 2 weeks
Right.
as on a date to be fixed by the registry. In that case, it may be accommodated in any other court.
A fixed date may be given, your lordship.
That in March. 19th of March.
Much obliged.
It's 7 for hearing.
May I please your lordship? My lord, kindly have a look at the last order.
Yes,
My lord,
last order.
My lord, kindly see the last order, my lord.
Passed by this court.
Yes. My lord, the petitioner is not in touch since the filing of the case. Thereafter, the honorable court was pleased to order the OC to concerned to submit some report. It is submitted accordingly. Thereafter, my lord, I was directed by your lordship to issue some notice to the party if I can contact. I have failed all till I have sent it as per your lordship order, and it is the letter is sent that is refused to be received. So send it.
It is refused.
Kindly have a look at the order, my lord, your lordship.
So you have no contact with it.
No contact since filing, my lord. So that after the first step. Thereafter, no filing, no connection. Till see the I have sent the letter.
Yes.
Giving details of including annexing the order also, my lord, by your lordship's order.
It is kindly see the backside, my lord. Refused and RTS means, my lord, send send back to sender, return back to sender.
Otherwise, it was a case for quashing or what? Oh, no, it is a revision, na?
Yes, my lord, for maintenance of my lord, 1,000 interim and all these things. My as per the OC's report.
Amicably settled or I don't know.
I don't know, my lord. As per the OC's report, my lord, it is that kindly see, my lord, that 5,000 has been paying by him to her. Thereafter, it is not stopped for 3 years, as per OC's report, not to me, my lord. So thereafter, they do not know what is happening. There are 4-5 cases pending, my lord. I have mentioned the last.
Yes, you have already mentioned.
And
In that case, the registry will last issue a notice. Otherwise, what would?
maintenance limited role, my lord.
The state is very limited.
My lord, may be closed.
But where is your respondent? How many respondents are there? State is to format.
State and the information.
And other respondents appear? No.
No,
Not
my
all.
lord. And my lord, and that regard also the OC's report is there. They contacted with the lady, and they have got some information, and they said that they were receiving 5,000 per month, but for last many years they are not getting it. More than that, they do not. Just kindly see the all of the OC's report. It is in the file, perhaps.
OC's report from which page?
My lord, not page, my lord, is separately, my lord. It was
separately.
It was given by the London PP, my lord.
Oh yes.
It was mentioned in the earlier order also. Yes.
5,000. So what to do, Sharma? They're not responding, refused. If they're not interested, let the matter be closed at the state. Or registry may be directed.
My lord, registry may be directed.
One last chance, maybe.
My lord.
You will be exonerated. Criminal divisions. Part Mr. A.K. Talukdar, the learned counsel for the petition. Part Mr. R. Sharma, B. Sharma, the learned counsel. Appear on behalf of the respondent. None appears on call for the respondent. It is submitted by Mr. Talukdar that in pursuant to the order dated 01/12/2025, he again sent a notice to the respondent, to the petitioner through speed post, but from the postal receipt, from the postal receipt, it is endorsement. It is seen that she refused to. He refused to receive the same, and accordingly, it is returned back to the same.
My lord, it may be made part of the record.
Yes. Mr. Talukdar further submitted that after just after filing of the present case, the petitioner did not make any contact with the discounting, and in spite of several attempts made by the discounting, he did not respond. And finally, as per order of this court, he also issued the notice through the speed post accompanying the order passed by this court. Accordingly, Mr. Talukdar submitted that he may be his name may be deleted from the cause list and cause list. Mr. Sharma, the learned petition people, also submitted in this regard that the last occasion one report was submitted by the OC Kamalpur police station, wherein it is stated that only after that the respondent number 2 is receiving this 5,000 for its maintenance. But since last 3 years, she is not receiving any maintenance from him. But that apart, there is no other mention about the present status of the present petitioner as well as the respondent. In view of this, the learned counsel for Mr. A.K. Talukdar is hereby Gauhati. He is allowed to withdraw his name from the present case, and accordingly, he is also hereby directed to delete the name of Mr. Taruk from the cause list, and stop the notice as well as the report be kept with the case record as a part of the case record. However, considering the overall, considering the all aspects of the case, this court finds justified to issue fresh notice to the petitioner as well as the respondent to raised
Private respondent.
respondent number 2 to raised, and the raised will be the needful evidence. The case may be listed in due course. In due course. Your name has been,
Yes.
you are allowed to withdraw your.
Highly obliged. My lord, initially he came against interim 1,000.
Wow.
And here,
A report says
here
that
he is saying getting 5,000.
5,000.
Not no, my lord. Obliged, my lord.
We should have list accordingly. We should have got due course.
29.
Mr. KP Pathak was appointed as an amicus. So he is not available, I think, now. Most probably the senior advocate KP Pathak is not here. Most probably the other KP Pathak.
No, he's Adi Adi.
Son. Yes.
My lord, he was there, my lord, but in the first half he was there, my lord. In the first half he was there, my lord.
Oh, has he informed anything?
My lord, he informed that he has not received any documents, my lord.
Pardon?
Any documents, my lord.
No, paper book has been
not
he has
received, my lord. That's why.
prepared and given to me. A copy I have received.
No, copy of the paperwork you have received?
I have received.
But that amicus could not receive, my lord.
So
He
has not
informed
received.
me, my lord.
And who raised it to be right? Oh, here you have also received.
My lord, received, but at present not there.
Anyway, okay then, we'll try to fix it, but may not be in the month of February because but paper book to copy kuru did go paribo ki ase.
Registry
will
Registry
yes,
provide.
registry. Heard Mr. Y.S. Mannan, the learned counsel for the appellant. Also heard Mr. B. Sharma, the learned additional PP, Apprehension. However, no one has represented the respondent number 2. So it is earlier represented by Mr. K.P. Pathak, the learned amicus. However, it is submitted by Mr. Sharma that the learned amicus had informed that he has not received the copy of the paper till date, hence not in a position to argue the matter. In view of this, the registry is hereby directed to furnish a copy of the paper book to the appointed learned amicus curiae within next week, so that the matter can be heard on the next date of listing. It will be on 17th of March. Otherwise, February we don't have any date. We'll do 17th of March. I have seen he is in custody.
He is in custody more than 3 years.
More than 3 years. Just do one thing. If those persons who are in jail, actually we should give priority to that cases. So in that case, if 17 other matters is listed, you just remind us or we can upgrade the matter otherwise.
He is coming.
Oh, acha. Yes. Anyway, we have passed the order directing the registry to make a copy of the paper book and to furnish it. Okay.
Make date fixed.
We have furnished, fix a date also on 17th of March. So invariably on that day, matter should be heard because it is the person is in jail.
Obliged.
Yes, start.
May it please the lordship. Lordship, if this matter
Here
pertains
the
to
state is there.
Minor state is here, my lord. Before starting my colleague, my lord, here up to date CD was called for, my lord. Yeah, we have received a CD, but not up to date, my lord.
my lord, the problem is that my lord, from my lord, they perused the order 24/10/2025, my lord.
2410.
24, this honorable court had directed to issue the updates CD, but till date they have not received. And then my lord had verbally said that if the up to date CD is not, then the matter will be heard at length, and it will be disposed of. But till that they are saying that they are not having the up to date CD.
My lord, CD received.
We are languishing in jail, my lord.
My lord, here we have received the case.
But as per your information, it is still under investigation.
Till
And
date,
since
charge has not
now
been
see
filed.
the criminal petition, from the criminal petition itself, it is seen that it was filed on 2023. That means 2 years or more than 2 years had already gone.
Mine.
So now still the matter is in investigation stage.
My lord.
Is it
Then what
possible,
they are
my
doing
lord?
then?
My lord, here in the lordship kindly periods in the last occasion they are also absent, my lord. Petitioner was absent in the last occasion, my lord.
Acha, acha.
That's why my
Will
lord,
it be, my lord?
perhaps it was my lord sent for up-to-date CD, my lord.
But due to some causeless
Oh, received the case diary.
Receive case they received, my lord, but
Oh,
not
acha,
up-to-date, my lord.
So it was updated till 1/5/2020.
Mine. That is why, my lord.
On that last occasion, you were not there.
My lord.
But due to some miscommunication, the
Maybe,
causeless
maybe,
that have been
I'm not
heard about,
sure.
My lord, one that may be
the
fixed, my
fact
lord,
is-
for
but-
final hearing.
But
my lord.
but the
the
fact
last
remains
In the
order
meantime, my
my
lord.
lord, the period of 24/10/2025 order, my lord.
that I have already paid.
Fine.
But the question is that it is not a case that they have not received. They have received the case diary on 6/1/2026. But most probably for updation, it was sent back.
Fine.
Now, what is your say? Without the now this
No.
is the other case diary.
Yes,
Okay.
yes, my lord. It is not up-to-date, my lord. It was not up-to-date. Sent.
Till date, the charge sheet has not been also filed, my
My
lord.
lord, here, lordship
Nothing
fixed
is-
one date, my lord, in the month of March, my lord, for final hearing, my lord. In the meantime, we will send back the case there for updation, my lord, and for final disposal. my lord.
And on the
issue
last
is
occasion, the order of returning back or
Right.
sending back was not there.
not, perhaps not.
So it is still with you.
Mine,
Why are you keeping with you then?
mine.
But the
And the
difficulty
issue,
part is that my lord, the petitioner is languishing in jail since 2023, in spite of having the UNHCR card.
Languishing in jail has
Yes, my lord. They are in jail.
they are the Rohingya
Rohingyas, my lord.
foreigners matters, my lord.
Rohingya.
That issue
It's
is
a
serious,
sensitive matter, my lord.
serious nature, my lord. That's why, my lord,
Rohingya
up-to-date
sensitive
CD is also required, my lord. What is the
How many
issue?
persons are there?
There are, my lord, as per here, there are kids also, my lord. As per total 18 persons,
18 numbers.
18 numbers, and there are 3 kids. Back then, 2023, they were 9, 7, 8 years. And they are still in jail, my lord. It's a very sensitive matter, but my lord, they, in spite of having the UNHCR card, they are still in the jail, my lord. And they were arrested when the UNHCR card was valid. In fact, my lord, I have submitted one judgment of
Yes,
this
I
Honorable
agree.
High Court, which says that the matter can be quashed even if when they have UNHCR card. And the arrest which have been done is illegal arrest.
Obviously, it is a sensitive matter. Otherwise, they are in jail for last 2
My lord may heard this matter because they are in the jail, my lord. Or my lord may give a short date, my lord. Let them get the case diary up to date.
Now see, very short date will not serve your purpose
That is
also
also true,
because
madam.
it has to be returned back. They will come and case diary will be returned back, and then only the updated maybe if we get. In that case, I don't think that a very short date will serve the purpose. So
Then, my lord,
let the case be listed within a reasonable period so that it can be.
My lord may then fix a date in the month of March and let the matter be disposed in the file if the up to date case diary is not here, my lord. Because from the other hand side, they have been taking in dates regarding the up to date case diary is not available, up to date case diary is not available.
Only one
My
day,
lord
my
may
lord.
peruse the
Only one day. Lordship may if argued on that matter, my lord. Lordship may kindly pay last order, my lord. Last 4-3 orders. Lordship may kindly pay.
4-3.
No, Lordship may kindly earlier orders, my lord. Then it will be clear, my lord.
earlier order.
Whether due to the fault of our, my lord, the case is lingering, my lord. That Lordship may kindly pay orders, my lord. Earlier orders. They have also taken time.
No, my lord, we have taken only 1 or 2 times, my lord. The rest of the times are taken by them, my lord.
You are Mr. A.R. Burba.
A.R. Bura.
Heard Mr. A.R. Burba, the learned also heard in Sharma, the learned additional PP submitted by Mr. Sharma that they have not received the updated case diary. Though he was instructed to obtain the updated case diary by order dated 06/01/6. Next, that context, Mr. Borba, the learned counsel for the petitioner, raised objection and submitted that the case is pending since 2023, and all the petitioners all the petitioners are still behind the bar for more than years. And matter is also very sensitive. And in the order dated, which order you are mentioning?
My lord, 24/10/2025, my lord.
24/10.
My lord, मैं
By order dated 24/10/2025 also, the learned public prosecutor was directed to furnish the case diary on or before invariably on the date of listing. Next para, Mr. Sharma submitted in this regard that on the last occasion the CD was received, but as it was not updated one, and the last entry was only up to 01/05/2024. The case they therefore calling for the updated one. And in the same time, he also submitted that no representation was there was no representation on behalf of the petitioner on the last occasion. Next, considering all the submission made by learning counsel for both sides, the state respondent is hereby directed to immediately return back the case diary with a direction to IO to furnish the updated case diary on or before the next date of listing. In default, the IO may be served with a personal so-called notice. In the meantime, the matter may also be heard in absence of the updated. List accordingly which date? Sharma, you say because it has to be returned back.
Return back from Silsor, my lord.
From Silchar?
Silsor.
Oh,
Last part of March, my lord.
may be listed on 24th. It's a Tuesday, my lord, hearing date.
it's a Tuesday.
Yeah.
Okay, then we are listing it on 24th
Mine.
of March. You just ask the IO to
My lord.
return back the take back the case diary.
My lord.